Mention item number 24.
24. Yes.
Lordship, the matter kindly be adjourned for today.
The request of the learned counsel appearing for the petitioner list this matter again on the 19th of March.
Lordship, we are on interim, let me continue.
The interim order passed earlier continues. Yes.
Deeply obliged.
May I please, Your Lordship? Lordship, I beg to mention item number 12, Lordship. There is a joint prayer from the petition and the respondent side. It was sent to mediation, but it failed. So let it come for admission, Lordship.
It is there for admission.
No, Lordship, a
Fixed.
report was called for.
Ah,
The report has not come yet, Lordship.
okay.
An updated report. So that, but as per the parties, it has failed.
It is filled. The counsels for the parties jointly submit that the mediation has failed, although the report is not available. Full stop. List this matter again on when?
After 3 weeks.
After 3 weeks, any date, Lordship.
23rd of March.
23rd. Lordship, there is an interim that may find.
Interim order continues.
Deeply obliged.
May it be please, Your Lordship. Lordship, item number 1, Lordship.
1.
1, Lordship. In this case, Lordship, we have filed an additional affidavit, Lordship, yesterday that may be controversial.
8, please, Your Lordship. I beg to mention item number 8, Lordship.
8.
Kindly pass over the matter for the day, Lordship, and fix it on 6 March, Lordship. 6.
At the request of the learned counsel for the petitioner, list this matter again on the 6th of March. Yes.
Lordship, I pray for listing of a matter before this bench. Bail application.
Assign a senior bench. There is a senior bench, madam. You told.
Lordship, the matter came up in the before this bench on 19th of February,
Ah,
wherein you ordered for listing it on Monday, that is on 23rd of February.
ah.
But it is in the order sheet, it has been inadvertently written as 23rd of March, Lordship.
Yeah, allow koi play. Allow koi do. Allow.
May I please?
Yes.
Lordship, I beg to mention item number 10, pass over the team, my lord. And short tip may be given.
At the request of the learned counsel for the petitioner, list this matter after. When?
If possible, my lord, Friday.
27th.
Friday applies. my lord.
Motion to 27th.
May I please, Your Lordship?
Yes.
I beg to mention item number 20, Your Lordship. Due to some personal difficulty, the council will not be able to appear before this honorable court.
20.
20.
You receive the case diary.
Item number 20. The learned APP submits that the case diary has been received at the request of the learned counsel for the petitioner. List this matter again on.
Next week, Your Lordship.
Have it on 11th.
Much obliged.
May I please, Lordship, with the consent of other side, Lordship, I beg to mention item number 22, Lordship. Can you pass over the matter for a day, Lordship?
At the request of the learned counsel for the petitioner, list this matter again on 18th of March.
Lordship, interim order is there, Lordship.
The interim order continues.
Battling to Lordship. With the consent of the opposite party, I beg to mention item number 17, admission code. It's 2 weeks time.
So we are
On a-
for number 2 of Y, Lordship. 17.
17.
For Y, Lordship. A date may be fixed, Lordship.
Hmm.
Maintenance case, Lordship. There is
On the request made by the learned counsel for the petitioner, which is not objected to by the learned counsel for the respondent, list this matter again on.
You can be 5 or 6th of March. Lord.
You'll have to take it sometime after the 11th,
12th of March.
12th of March.
Interim may be continued.
The interim order continues.
May I please, Your Lordship, Lordship, as per the instruction of my client, I wanted to withdraw item number 36, Lordship. The matter may be disposed of on withdrawal, Lordship.
The learned counsel for the petitioner has submitted that there is an instruction from the client not to press the matter in the present form. Accordingly, this AB is closed on withdrawal.
So,
मतलब देखिए मत ठीक कोई
This motion be a
Item 3.
Mr. Dotto, they have filed some additional affidavit which is being called for.
Fine.
Let the affidavit come, then we can take up the matter.
At 2, my lord.
Ah, yes,
At 2, my lord.
we'll have it at 2.
I'm not there.
1 and 2 to at 2 koi dibo, huh? Hmm.
May I please, Your Lordship? The regular bail application, my lord, I have read page number 10, my lord. Allegation of fraudulently transaction of money, my lord, from the bank account of the informant, my lord. Rashidul.
Call for the case diary.
My lord, in this case, my lord, no notice was served to the petitioner.
Eh?
No notice was served to the petitioner under section 35(3), my lord.
Hmm.
This is the clear violation of until and earnest Kumar.
At page 18.
Yes,
18.
it is, my lord, for
Reason
bail
for non-issuance of notice. They have given some reason.
Supreme Court held that, my lord, it is mandatory, my lord.
Let the CD come, we'll decide.
Short date may be.
Call for the CD. List again on when?
13-3.
Huh?
13-3.
13-3. 13-3.
All right.
Pardon me, Lordship. In item number 8, CD may be called for Lordship.
Item number
8, Lordship.
8. Acha.
Already mentioned.
8. Call for the CD. List again on 6th of March. Same day. 6th no about it, yeah. Then the date will go ahead. 13th of March. No problem.
Item 4.
I say go some more people. 13.
May I please, Your Lordship?
Ah,
Lordship, with the section 21B, Lordship, intermediate quantity, Lordship. Already, it's around undergone 51 day, we had a bar, Lordship. Maybe here, Lordship, today is 51 day, Lordship. And he is not main request, is another person, Lordship. Mustafa is the main request, Lordship. He is a rickshaw driver, Lordship.
When can you have this CD? 51 days.
Lordship.
Huh?
Please.
6th? No. 6th of March. CD.
Item 5.
Wait, this is
Hmm.
Lordship, this is a regular bail application, 55 days in jail custody, Lordship. But Lordship, may I take Lordship, can you peruse 193 of BNSS, Proviso 2, Lordship? Here, Lordship, statutory period for completion of the investigation is 60 days, Lordship. Now he has Lordship 55 days in jail custody to that, Lordship. POCSO 6 is there. 6 of POCSO is there. But 60 days is there, Lordship, to complete. Proviso 2, Lordship.
What is the allegation?
Allegation, Lordship, adolescent love, Lordship, adolescent relation, Lordship, having physical relation, Lordship. The boy is, this petitioner is 19 years and the girl is 17 years, Lordship.
But FIS is 17 years promote had forcefully raped her at that moment. So POCSO is there true.
Otherwise 60 days statutory.
No, no, 60 days.
Because case was registered under 64 Lordship 2M and 6 of the POCSO. Their Lordship 193 Proviso 2 say the investigation has to be complete within 2 months.
26th
Case
of
was
August.
registered under 64(2)M, Lordship, that is BNS, and 6 of the POCSO Act, Lordship.
Hmm.
And 193 of the BNS says, Lordship, it has to be completed within 2 months from the date of lodging of the FIR.
Can we have a copy of the FIR anytime before that? Maybe second? Huh? Just let us find out whether there was
Lordship.
penetrative assault or not.
Otherwise, adolescent love, Lordship, because of
Hmm?
19 years and rape.
For that, we would require the statement of the girl,
Yes, Lordship.
and then we would require the notice to be served upon the minor.
Yes, that is the.
Is it not? But if you are going for 55 days and 60 days only, we would just like to see on the second whether there is a medical, what does it reveal? If there is no penetrative assault, we can consider.
Second.
List again on 6th, on the 2nd of March, allowing the APP to have his, have the CD.
Highly of it.
चाहिए लिखे, the petitioner has already completed 55 days in custody from the date of his arrest. Yes.
May I please, Your Lordship?
Ah.
Lord, this is, Lord, NTPS, intermediate quantities involved in this case, Lord.
Ah.
Petitioner is behind the bar since last 46 days, Lord, as on today, Lord,
46 days.
46 days.
How soon, sir?
9th of
9th of March. 9th of March. Call for the CD 9th of March.
Lord, in this case, Lord, it is also intermediate quantity, Lord, but as on today, Lord, 57 days, Lord, he is in custody. So may I pray that day after tomorrow it may be taken up, Lord.
Huh?
Otherwise, Lord, the mandatory period would be over.
57 days.
57,
Hmm.
because he was arrested on 29/12.
Then Lordship, okay,
27th.
27th.
We'll take list on 27th. The petitioner has, so the counsel for the petitioner submitted that the petitioner has completed 57 days as of today in custody. APP to have his instructions.
I'm obliged.
Make please, Your Lordship.
Hmm.
Page 9 is the affair. Whatever my petitioner was working as a painter, my lord, in the house of the informant, my lord. There's a police report also. I'll take a pray, my lord, to that police report, but the affair is page 9.
Hmm.
Not affair, my lord. It is alleged that these things were stolen from his house, my lord.
Hmm.
Now, these are the things, my lord, which are stolen from the informant house. Actually, my lord, one of the petitioner before Your Lordship, my lord, he was working as a painter in the house of the
Hmm.
informant, my lord. Page 14, if may I take Your Lordship, page 14. There's a police report, my lord. Page 14, my lord. May I take, my lord? My lord, it is clearly stated, my lord, by the police, my lord.
But if we allow the people to react like this in case of
No, Lord,
not being paid money,
no, my lord, kindly see, my lord, page 14. May I
now
read?
we have seen
May I read, my
the
lord?
the money was not
But
paid to him,
it was taken.
so he takes away everything.
But my lord, the question of theft, my lord, does not, because it was taken in front of his roommate, my lord.
Oh, this is like that saying that this is not theft, this is dacoity, so he should be granted bail.
My lord, admitted he has to pay 20,000 rupees. He has paid a check also. Check is annexed.
Check is bounced, huh?
Check is bounced, my lord. Now, my lord, repeated, I'm poor man, my lord. Repeated, I'm going there, not payment, not receiving my.
What about the items? You've sold them off?
No, my lord. But possibly it is taken by the
Not,
police.
no possibly. If you go by possibly, then
No, my lordship.
your possibility comes down.
My lordship may kindly see, but apparently, I stated there was a painter working there with another person. It was his legally enforceable debt, my lord. Not paid, my lord, check bounce. What to do, my lord? Poor pen, my lord. And my lord,
He has admitted that he has taken it away. He will return it.
for that I will press the case. But till then some protection, I will return, my lord, if he pays the money. So some protection may be given.
Second part also there.
Huh?
He pays the money, I'll return it.
If he pays the money, I will return it, cannot be.
No, no,
He has to return it
if-
for us to
my lord,
consider.
By this time, my lord, the lordship, my lord, I will return the articles, my lord. And, my lord, there is another, I can file a NI case also.
In cases of sudden spurt of anger, when someone attacks physically and a person dies, we go by rash and negligent act. This is a rash and negligent act, not intentional. Huh? What to do? We'll give him the interim. Let him go on. Return the articles. Huh? Mr. Goswami?
Okay.
Personal matter. Heard Mr. S.M. Abdullah, learned counsel appearing for the petitioner. The allegation is that the allegation in the FIR is that the petitioner had taken away certain items from the possession of the informant, as money was owed to him and the informant was trying to change the residential address and moving out without clearing the dues of the petitioner herein. The petitioner herein, the learned counsel for the petitioner has submitted that the articles are all available and can be returned. However, the act was done only in a fit of rage because the legal dues were not paid to him. In these circumstances stated, this court is of the opinion that the petitioner may be allowed to appear before the investigating officer of the case on or before the 6th of March 2026. To cooperate in the investigation, the petitioner shall also return all the articles which
If
have
not
been
seized by the police, if not already seized by the police.
shall return all the articles to the informant, if not already seized by the police. Stop. List this matter again on the 13th of March. I will have it on 20th of March, 2026. Stop. The petitioner shall not repeat such offences
By the lordship.
during the period of. Item? Yes, madam?
Lordship, the FI, in this case, also already charge sheet was given.
Huh?
Application is filed after section 483. The victim has lordship already been examined, lordship. On last occasion, lordship, the scanned copy of the LCA was called for, lordship. But
Just a minute.
victim statement,
Just a minute.
lordship, already 270 days.
How many days? When was he arrested? 17/7.
70 days.
Do we have this? Do we have PCR? is here?
Copy, Lordship will find the deposition of the victim. It has already been done. Second page itself. Lordship.
Victim was recorded in camera, lordship.
Huh?
Victim was recorded in camera, lordship,
In the first part is clear.
on 8/1/20.
Wait. Mark. Mark.
Hmm. Yes, what do you say?
Victim is a minor boy, which was in debt.
But then also lordship solicitors given lordship after it file a bail petition at the court below, and here also it is pending lordship, 217 days lordship. And the victim was already examined lordship. Now, no, there is no case of lordship tampering also lordship, he is
Huh?
behind bars.
What does he do, this petitioner? For a profession? Huh?
Now she works in the saloon lordship.
He works in a saloon.
Yes, lordship. And that the victim was a regular lordship, he used to go there. Class, I think he's a standard 8 boy lordship.
Victim statement is there, informant is an adult. 270 days. Age of the arrested?
Lordship,
Lordship,
arrested
around
on
20.
No,
18/7.
age.
18/7 lordship.
23 years, around 23 years, petition.
Without going to the vicinity of the locality. Can it be considered?
Also can consider, otherwise, lordship, if we go on merits, lordship, the evidence is very,
No, there's a difference. In the FIR, it is of penetrative. In the statement, it is of touch.
some strict condition of it.
Strict conditions, he will not visit. Yes, you are for the.
I'm just Lordship.
Huh?
Lordship can consider considering the period of detention. Period of
Yes.
detention.
You have interacted with have you interacted with the victim or the informant?
Lordship.
Have you interacted with the victim or the informant?
No, I have gone through the record only.
I think we'll put in
As because
the.
the victim has not appeared, therefore.
Huh?
As because victim has not appeared, therefore I make a just appointment.
No, I understand. Yes, he would be away from all sorts of social media, and he will not visit the locality. We will impose the strictest of conditions on him. Anything to do with social media or him found anywhere near the vicinity, the bail gets cancelled immediately. We'll put that bail. He will not be in social media or anywhere else. Nothing to do. Because he is trying to.
He is regular, he is there.
He's roping in people, huh?
He regularly appears in the trial.
Regularly, lordship. Today also raise lordship, this one evidence of the informant lordship.
No, he's appearing regularly means?
He will, after being released on bail.
Oh, yes. Regular. He will not be found in the locality, and he should not have any social media thing with him. He's using it as a bait to get young children. You know? Yes, heard Miss D. Gogoi. Learned counsel appearing for the petitioner also heard the learned APP. And Mr. Diula. Learned amicus curiae. Stop the trial court record. The trial court records reveal that the statement of the victim has been recorded. Stop. The petitioner has been behind bars for around 270 days till now. Stop. Having gone through the records and the submissions, this court is of the opinion that keeping the length of detention and the young age of the petitioner in view, the petitioner can be enlarged on bail, subject to strict conditions which would not hamper the ongoing trial, and or would not cause inconvenience to the alleged victim. Full stop. In these circumstances, the petitioner is directed to be released on bail if not wanted in connection with any other case, on furnishing a bond of rupees 30,000 with two sureties of the like amount, one of which shall be a local resident of the jurisdiction of the competent court, of the trial court. Then there are some other conditions. He shall not enter the locality. He shall not contact the victim or family members or any other witness in any manner whatsoever. The petitioner shall not indulge in social media activities during the period of trial in any manner whatsoever. You ask him to keep away from the social media. If you find one instance of his going to social media again, disposed of.
Item 26.
Lordship, what is the,
Huh?
26 Lordship, the petitioner has submitted Lordship that this period has exceeded the statutory period.
It
So he
has.
yes, so he was granted bail Lordship. And Lordship will find the order last. Yes.
21-1-2026.
After Lordship, the charge sheet was called up.
Huh?
Charge sheet is before your Lordship.
Huh?
Even though Lordship, the charge sheet was filed on 3/1/26.
Huh?
That is within the period of limitation. But Lordship, from the order that he has produced, the court took cognizance of the offense Lordship on 9/1. So if it is 9/1 Lordship, then it will be 61 days. So he is entitled for default bail Lordship. So Lordship, he is not present here, so Lordship, can it be after a few minutes if he comes?
If he's there, we could have closed it if after some time.
Let me please, my lord. This
Huh?
is a substantive case, my lord,
Huh?
regarding the NDPS case, right? And the accused person has already been behind the bar for 266 days. And here are 3 prosecution witness has already been done. And here the one point is that the allegation is that the 2 accused person arrested inside the train, but so far the Caesar list is concerned, page number 19, the name of the accused person has not been shown. And to establish the conscious position of the page number 19, follows it.
Yes, sir. Mr. Goswami.
Lordship. Here it is described from whom it is seized.
Huh?
Here in the Caesar list, it is described in the point number 4,
Hmm.
from whom seized SI RPF Sohanlal Pradhan.
He was leading the group, that's why his name is here, Lordship. Train was moving out, Lordship.
He was?
He was leading the team, Lordship. Train was moving out, Lordship. That's why his name is here.
But the so far to establish the conscious possession of the ganja,
Concept
they are
was
the
recovered from them also.
name of the accused should be there. Because in this case, there are 2 accused. The individual quantity must be established there. How much, what the quantity of.
Are we arguing the merits of the trial, or are we trying to see whether a bail can be
But,
granted or not?
my humble submission that the so
Huh?
far the accused person has already been 266 days, and 3 numbers of prosecution has already been done. And he belongs to the locality, my lordship.
And humble submission.
Here
my
it is
humble
charge
submission-
framed on 15/9/25.
Hmm?
Charge framed on 15/9/25.
Hmm. That will be
And
accepted.
as per scan copy, two PWs are examined, but as per.
He
his
says
instruction,
three.
So
You say
21.
three have been examined.
Yes.
21 is the last date, so it was gonna count that this third prosecutor.
It is
maybe
available in with me.
Hmm?
So out of 6, 3 examined, so
Yes.
remaining 3 is there, Lordship. Wait for the 3 prosecution examine, Lordship. Recovery of 21 kg 700 grams of ganja,
21 kgs.
Lordship. And 21 to Nico. Request.
It's a Caesar witness.
Last
Lordship.
date examined 21 to
It-
26.
It has goes in favor of the accused person, Lordship.
Needs it to be here, no? Yes, no.
Three witnesses are yet to be.
Examine.
With,
Next.
accused person belongs to the
20 kilos, huh?
locality, my lordship.
Huh?
Accused person belong to the locality to see
Ah,
only suspect and has
20
already been
kilos of ganja
uh,
on a train.
166 days
Huh?
behind the bar, my lordship. And prosecution with paper of the accused person, my lordship.
Hmm?
Cross-examination, I have submitted now. This is in favor of the accused person. Here, the Caesar witness has not mentioned that he is not aware about the seize of the said narcotics. my
Then we
lordship.
have to go to other three PWs.
Is a-
I don't know anything about the occurrence.
Yes. Is the Caesar witness, my lord. Taking all this aspect and to see the locality of the accused person,
Hmm?
my humble submission that he may be allowed to go on bail, my lord. Any condition may be imposed, that is really vexing.
I have to wait for another.
It has been submitted that three prosecution witnesses have been examined till date. When is the next date fixed?
23 March.
23rd of March. List again on the 27th of March, along with the
Issue reminder for updated status report of that case.
issue reminder to the TCR for updated, issue reminder for updated scan copy of the TCR showing the statements of witnesses recorded on 23rd of March, as has been stated by the learned counsel for the petitioner to be the next date fixed. We'll have it on 27th of March. Let one or two more witnesses come.
Possible.
Item 26.
Your lordship.
Hmm.
Lordship, I apologize for not being present. My lord, on the earlier occasion,
Hmm.
on 21st of January, my lord,
Huh?
this honorable court, after perusal of the records, was pleased to grant bail,
Hmm.
primarily a point that the charge sheet was placed on the 61st day, my lord. And this is the offense of 60 days of default period.
They say the charge sheet was placed on 60 days, but the court took it up on the 61st day.
But my lord, yes, my lord. And my lord, that has already been placed, my lord, the official certified copy.
Huh?
And my lord, as per the, my lord, dicta of the apex court and as well as clarification by this high court, my lord, the actual date when the charge sheet would be considered to have been placed is when it is laid before the eyes of the concerned jurisdictional magistrate or
Yes.
judge, my lord.
Now, he cannot go and stand before the magistrate and put it up.
Yes,
He has to put it in some filing department.
yes, my lord.
He has to
And
give it
my-
to someone else.
Yes, my lord. And there's nothing.
When did
on
he do
record.
it?
Lordship is very correct to that
When
extent.
did he do it?
So, my lord, there is nothing on record to show that that was prior to 9th of
Okay.
January, my lord. Even otherwise also, my lord, even the POCSO is there, my lord. It is the case that the informant victim herself had sent the video to the accused person,
Hmm.
and the accused person has forwarded to one another person, my lord.
Hmm.
It's not that no physical touching or anything is there, my lord. Even on merits, my lord. Now trial is progressing, my lord. Section 12 and section 15 of the POCSO is there, my lord. Maximum punishment of 3 years. my
There was no physical contact of any physical. So you stay away from the social media again
lord. Yes, my lord.
for a
That I
certain
ought to
period
do,
of
my
time,
lord.
at least till the trial is over.
That I ought to do, my lord.
Eh?
With connection to the.
When the fingers are not in control in sending messages, forwarding,
My lord. That ought
someone
be
has to
there,
draw the line.
my lord.
He has appeared in the exams.
Yes, my lord. Subsequent to his release, my lord, whatever academic exercise he could take, he has taken, my lord. He's already out, my lord, on interim regular bail.
By an order dated 21/1/2026, the petitioner was directed to be released on bail as an interim measure in connection with Tinsukia PS case number 390 of 2025, subject to the conditions recorded in the order itself. Today, the learned APP has submitted that though the charge sheet is dated 3/1/2026, comma, the same was placed before the learned court only on 9/1/2026, and therefore apparently the period of 60 days is over. Full stop. The Mr. D.K. Boydya
My lord.
and the counsel for the petitioner has submitted that as per the judgment of the learned of the apex court, comma, the period of 60 days has to be counted on the day up to the day on which the charge sheet is taken cognizance of by the trial court. Full stop. In such circumstances, the petitioner is entitled to the privilege of default bail. The earlier protection granted to the petitioner is hereby made absolute, subject to the condition that the petitioner shall restrain himself from indulging in any social media activities. What is his age?
My lord, just 18 years, some months, my lord.
Without the supervision of either of his parents. Mr. So-and-so appears as the appearing as the amicus appointed by this court, has suggested that has also endorsed the views of the learned counsel for the petitioner. Default bill.
Deeply obliged.
28.
May please, your lordship.
Hmm.
76 days, lordship, behind the bar and innocent person, lordship.
76 days.
Basically, lordship, this petitioner.
Huh?
He petitioner, lordship, before your lordship, he's the employee of a lordship, and lessee, lordship. He's the employee, the lessee of railway authority, lordship.
Hmm.
And he was only assigned duty to lordship supervise the goods that were carried out by the said train. Lordship first have the his letter, authority letter, lordship page 38.
Page 38, Lordship, page 38 is the authority letter whereby this petitioner was authorized to as a chief parcel supervisor at railway station Kamakya. So Lordship, on the day of occurrence,
Hmm.
the day of occurrence, Lordship, while this petitioner was supervising the unloading of goods from the rear part of the train, some police official Lordship interrogated him and he was brought to the police station. Subsequently, Lordship, all goods that were sent from Ahmedabad, they were seized. So my role is confined, Lordship, only with that I have to only supervise the goods that were sent in the railway.
Hmm.
So I have annexed all those documents, Lordship, kindly pass to the FIR
Hmm.
at page 30.
Huh.
May I read the FIR? Lordship?
Yes. Yes, what do you say? He's a person who is supposed to
Yes, Lordship, only
unload the goods. Are the goods connected with?
No, Lordship, when Lordship, this cough syrup, Lordship, this is a Schedule H drug. And Lordship, it can be transported and Lordship.
Understood.
Only for therapeutic use.
Huh.
That license has to be there.
Huh.
As per the act also. He did not have any document in.
Who?
The present petitioner.
The
Lordship.
present petitioner is a person from a company.
Yes,
That company is transporting the goods.
yes,
Some company is sending it to Assam
yes,
with or without a license.
yes,
Some company here is receiving it and transferring it forward.
yes.
This man is someone who is just to see that the number of 8 bags have come, number of 8 bags have gone out.
No,
Easy to look into the contents.
no, Lordship. He is the person who receives the goods from Gujarat. Here he receives it. Then from here he sends to the other places. Lordship. So in that regard, his responsibility changes. Because Lordship, if he is in possession of Schedule H drugs, Lordship, this codeine phosphate, for transportation, Lordship, he needs.
Was it being transported openly or was it inside some other package?
In the cargo, Lordship, it is stated as medicine. It is not stated, Lordship, that it is a Schedule H drug whose license is required to transport even.
So it has come from some place.
Yes.
Have those people been traced out?
They have been checked, Lordship, 67 notice has been given, nothing is there. For Lordship, kindly see the, I'm just producing the CD, Lordship. Yes, Lordship. Some sections, I have to.
What is this pharmaceutical thing you have given, this additional affidavit?
In additional affidavit, I have annexed the document. Basically, Lordship, what my line of finance submitted that I am the employee of a company. I am the employee of not company. And the employee of a Lordship on the transportation agency, Lordship. They are the lessee of this railway authority. So our duty is confined only to Lordship, receive the goods and deliver the goods in place, not to verify the documents. Documents have been verified by the railway authority themselves, Lordship. I have annexed all those documents in my additional affidavit also.
Lordship, kindly take up section 21.
Yes.
Section 21, Lordship, for a moment.
What goal NDPS? What does NDPS for? NDPS. If it had come in a truck, the truck would be in problem.
Yes.
It has been consigned to the railways.
Yes.
How many railway authorities have been?
Through the railways, Lordship.
How many railway authorities have been taken into custody for allowing this codeine to pass through without there being a license?
Lordship, because in the consignment which they have attached, Lordship, in the petition, Lordship will see.
Small fries. Why these big sections come only against these small people? Someone has transported it without a license on the railways.
Yes.
Someone loaded it, someone allowed it to come to Gauhati.
Yes,
Someone is allowing these things to be taken down from by
yes,
inspecting that particular letter.
yes.
What about those people? They were not required to look into the license part,
Yes,
whether that coding had a license or not.
For that purpose only, Lordship, it was seized, Lordship, because when it was unloaded, Lordship, I can show from.
There must have been one official of the railway on duty on that day.
Yes,
Was he taken into custody that in your presence this coding is coming without a license?
no,
What are you doing here?
no.
Then you don't need him behind bars.
Lordship will kindly see.
This is like asking the advocate clerk whether he has verified the UID of the petitioner while signing the affidavit or not. This is taking it too far.
Lordship will kindly see the,
He may have been a part of it,
yes.
but every crocodile is out and every small fish is in.
Yes,
Then get me the crocodile. We'll reject him like anything. We'll ensure that no more crocodiles exist.
it also doesn't. But then the small fish has to be left out of.
Small fish.
And here, Lordship, the investigation is still going.
Hmm.
And apparently, Lordship, this license is required. And he is in charge, Lordship, because he is fully aware of it, Lordship.
He knows it is coding, but he has not made a statement saying that I knew it was without a license. He said, yes, I'm bringing in codeine, I'm transferring every bottle, I'm delivering it to the pharmacist, I'm taking extra money for the delivery part.
Yes.
One sentence that I knew it was without a license.
That cannot be excused, Lordship. Because NDPS, Lordship, it is apparent, Lordship, the medicine, it's a different aspect, Lordship. This is Schedule 8 drug. It needs to be transported only with a license.
The persons who had loaded these things,
Yes,
you are still searching for them.
yes,
The person for whom he was unloading it,
yes,
is the search still going on for them?
Lordship.
They have not been able to apprehend
No.
these persons, the company runners. But the person who transfers it from the railway train to the pharmacy, he becomes a person who's required to be detained even after how many days?
76 days.
Huh?
76 days.
76 days.
In additional affidavit, I have annexed all those documents of open is west and supported is good trust. 76 days is gone lost.
In the additional affidavit, Lordship will kindly see the invoice.
Yes.
It all contains, Lordship, medicine. It
Medicine.
doesn't disclose.
So therefore,
Yes.
every person who was handling it in the sealed cover
Yes.
is under the impression it is medicine.
Lordship.
Prohibited or not is separate. It is medicine. Persons who are actually booking it and having it downloaded here are the persons who know what is inside.
But he is aware, Lordship.
Hmm?
He
That
knows.
is his statement before the police. We will not even,
Also,
in case it was something, but get us something updated. What is being done to the
Lordship.
other people? If he's being kept behind bars and the police are investigating by looking into the documents,
Yes, yes.
we are not happy.
The CD is before your Lordship in the last date also the CD was here.
Hmm.
So, Lordship will allow me to update the
You
CD.
update it.
I have annexed the loss, even license also loss, you will find page 55.
Huh?
This page 55 is the.
That is what we would like to have an updated CD on. You have given everything you can to this court. The documents which were given to you. What has been done on that? Or is it because we have got the documents, we have got one person with us? We require now to rest till the last date of the default bill. Can it be?
Yes, sir. Had I been the any discrepancies in the documents submitted by the authority to me and the documents I have given to them, then only that's the question of my liability will come.
Hmm.
Because everything is on record.
We'll see. When can you have the updated CD? You have understood what
Yes, yes,
this court has in mind.
yes, yes. I understand.
You catch the small one, be happy with it.
I understand.
This is not an investigation going on in the proper line, and we would not have someone suffer liberty,
Lordship.
loss of liberty because someone needs to sleep.
Yes.
When?
I'm excited.
12 or 13?
13th of March, no issues. 13th of March. Updated CD, huh?
See from Kamakya station only, Lordship.
Updated CD will, they will now wake up to find out who is actually responsible. Why do you worry?
Lordship may consider my interim prayer, Lordship, because they have the right to, Lordship, investigate even we are going at Ahmedabad. It will definitely take time. For timing, Lordship, I may be allowed, Lordship, I am ready to cooperate, Lordship, at all the point of time.
We'll consider every aspect on 13th.
13, Lordship.
On 13th, if they have something updated, we'll look into it. If they do not have an updated, we'll think over it.
Lordship.
Will we keep as a part head, Lordship?
On 13th March. From when are bail matters kept part heard?
Lordship, because it's on facts, law and facts, Lordship, both are there.
Huh?
Question of law and facts are there, Lordship.
Unless we reject it today, it will not come up on 13th before us. We can reject it today and have it on 13th. You can file a fresh one tomorrow, we'll have it on 2nd.
Like this.
13th of March, allowing the learned PP to have his updated case diary.
29, Lordship, there is an office note. The service report.
Everything's not been copied.
Steps were taken in the month of last quarter. Lordship, if I'm not wrong. Lordship, may I pray that
Scan copy is also not there.
Scan copy has been received.
No. 23rd, there is a office note scan copy not
Scan
received.
copy is not. Sorry, man.
Service report not complete, huh?
in the meantime, I will also take the instruction of
Issue reminder for the scan copy of the TCR. List again on when? 6th of March.
at least
6. 6 of March.
9 or 10 days.
11th of March. 11th of March. The learned APP shall have instructions on the service of notice upon the respondent number 2.
My lord,
Huh?
it will be on 9th, my lord.
9th of March.
9th.
Yeah, make it 9th of March.
Obvious, man.
This is item?
30, Lordship, there is an office note dated 23rd of February.
Huh?
Service report is still awaited.
PCR is reciprocal.
Service report is awaited, madam.
Yes.
What is it? But regarding respondent.
Service report is awaited on the respondent number 2. Trial court records have been received. Where is the FIR?
So I paid 10.
Huh?
Paid 10. Driver of the house, Lordship.
After 9 months, loss. After giving birth,
Hmm?
child, after 9 months, loss, they close the FIR loss. 9 months. After giving birth of the baby.
The service report has to be weighted on the respondent number 2. List again on 6th of March, allowing the learned APP to have a report on the service of notice on the respondent number 2. The trial court records have been received. We'll have it on the 6th or we'll appoint an amicus and go ahead.
What?
41.
Everything.
Ah.
The 483 application, Lordship, 239 days behind the bar.
Where is the
POCSO
FIR?
has been expected in this case.
Huh?
In this case, POCSO has been expected.
Why?
And your lordship, if the LCR is being received of the cross case, in wherein the informant has killed the father of the petitioner. And in that case also, lordship, they have been made a accused person for which the false allegation has been put against me.
Why?
Now, lordship, if the LCR has been received in regards to the Dhing PS 226/21, on the last occasion, the LCR has been called for.
Huh?
This is the case wherein the petitioner's father was being murdered by the informant's family. And thereafter, after 4 years, they have given a false allegation against the petitioner against POCSO.
It was 195 of 2022 PCR2. PCR2 কেতিয়া আসকচোন PCR2 কোনটো কেছৰ
টিচাৰ কল কৰিছে নেকি? টিচাৰ কল কৰিছে সেইটো ইচ্ছাটো কল কৰিছিলে নেকি?
হা?
মানে মৰ্ডাৰটো?
এই হা 116 হয় PRC কেছ নম্বৰ 195 নহয় ক'ৰ পৰা আহিছে এইটো জুডিচিয়েল মেজিষ্ট্ৰেট নগাঁও
ঢিং
ঠিক আছে
There is 195/22 is the
PRC
195/22.
নহয় এইটোতো অকল হেৰি হয় This is only the POCSO matter we have before us the TCR the other TCR is not here
It was called for.
It was
Ah,
called for in the last.
also call for the trial court record along with the scanned copy of the PRC case number 195 of 2022
Also, this is completely a false FIR against
Ah.
the petitioner, wherein he is behind the bar for 239 days as of today, without committing any crime, Your Lordship. That case was also in the committal stage.
Charge already framed on 1925.
huh
Charge already framed on 1925, Lordship, and no PW are examined yet. Last date was 6.
have page 14 for a moment do you see what we see huh
Yes.
we will not like to spell out what we are seeing but if it is similar to the document that we believe now please come to page 32 page 33 page 32 huh last lines see that
Yes.
then you will see page 33 done now how it is rejected no discussion
No discussion.
huh yes sir do you deny the case that there is a case between the two families regarding the death of
This is the, not a false case. This is the
uh-huh.
true fact, Lordship. The allegation imposed against the accused. is true, Lordship.
It is true but do you deny that there is a earlier case
No, no.
regarding the death of
Sir, this is difference case, Lordship.
but there is a case there is a case
But my learned friend has submitted those facts is reflected in the order also.
it is reflected
Yes.
now since there was an order of this court calling for the TCR of that case and has not been received why is it not received why is it not called for till now yes take down by the order dated 27/1/2026 this court had directed to call for the trial court record along with the scanned copy of the PRC case number 195 of 2022 from the court of the learned chief judicial magistrate Nagaon. The matter was required to be listed on 18/2/2026. There is no office note reflecting that the trial court records along with scanned copy of the PRC case number 195 of 2022 have been called for from the court of the learned chief judicial magistrate in Nagaon. In fact, the court records which have been received. Sir, Edu? Are of special POCSO case number 231 within bracket N of 2025. Full stop. Registry to call for the case records of call for the trial court record and the scanned copy of the PRC case number 195 of 2022 from the Court of the Learned Chief Judicial Magistrate, Nagaon, as already directed by the order dated 27/1/2026, list this matter again on the 10th of March. We will have to take that part. Or you could have had your certified copies. We would have taken that on record.
Can we release it before 10th of March?
Will it come before 10th of March?
We'll get a certified copy.
Huh?
We'll try to get a certified copy.
Before 10th of March, we've got 2 holidays on Tuesday and Wednesday, 3rd and 4th gun.
Alright.
Huh? 10th of March. Come.
Alright.
42.
Kindly the matter may be considered for the time being as my senior is on less in put one.
Time being.
43.
Next, yes, Lordship.
Yes, sir.
Lordship, comma, in between Lordship, 21B Lordship. It is recovered not from my possession Lordship. Kindly have a look at the Ezahar at page 15 Lordship, down below. May I read Lordship? On thorough search, down last para Lordship,
Page number?
page number 16.
But it is also scan report has not been received probably. Not received.
Lordship, accused in custody, 119 days in between Lordship, commercial, not commercial Lordship.
Huh.
And recovery not from his possession Lordship. On thorough search of their body, a blue colored bag was recovered from one Lalringtang Mar. I'm not Laltingam Mar Lordship. My name is Nakul Leon Kangshai. It is recovered from accused number Lordship 2. Possession of the accused number 2. And Lordship also kindly have a look at page.
Has he preferred any previous bail petition anywhere?
Lordship, yes.
Page 28.
Page 28 Lordship.
Lordship, kindly come to
And
page
extra
29, last paragraph. 29, last paragraph.
We will await the case diary, sir. The scan copy.
Lordship, kindly have a look at page 31.
Huh?
Annexure 5. Annexure 5. Lordship, please.
Annexure?
Annexure 5, page 31.
Page 31.
He is a HIV patient.
Huh?
HIV patient.
Asu? We will ensure that he is given the proper immunotherapy. There's no difficulty. We cannot discriminate or give an advantage on that.
This is judgment of our Meghalaya Lordship. It went to Supreme Court. Same ground Lordship, HIV positive patient. It was rejected by the Supreme Court.
But Lordship, here detention is 119 days. In between Lordship,
Case diary was called for.
No, scan copy. It is
Call for the case diary. The order says call for the case diary.
already charge sheet submitted, Lordship.
I don't know.
charges.
I don't know. The order says call for the case diary. We'll have it on the 9th. Huh? With the TCR, can it come? TCR 9th? No. 11th.
11th Lordship.
11th, or list again on the 11th of March. Call for the scan copy of the TCR. Let it come.
Case number 1 of 26. NDPS case number
NDPS case number 1 of
26.
2026.
Court of Special Judge Kasar Silso.
Yes, in page 2 you'll find it, huh? List again on 11th of March.
Like,
Yes.
Item 34.
May I please tell her?
Okay, after some time, he's going to the records, Lordship.
After some time.
45.
483 application. Lordship.
Hmm?
483 application.
Hmm?
Allegation section 316 subclause 3. I'm
Hmm?
behind the bar for 45 days as of today. FI is not 12. Your Lordship, the FI says the two persons, Parmanda Yadav and Om Prakash Yadav, were entrusted with some TMT bar 34,960. I am not appearing Parmanda Yadav or Om Prakash. I am Santosh Tiwari.
Why are you arrested?
One of the accused persons, he said that he had sold some TMT bar to me.
Hmm.
That's the only this much here. Even this 31,000 was page number, Your Lordship, the seizure list, page
Hmm.
24. 31,280 TMT bars were recovered from this person, Your Honor. That is Pramanda Yadav and the Om Prakash Yadav.
Hmm.
But nothing was recovered from me, only mere allegation brought by this accused person, Your Honor. That's some of the, already 31,000 out of 34, 31,280 kgs were recovered as per the seizure list.
Hmm.
Only mere allegation brought against me and I am behind about 45 days. Your Honor.
Yes, sir.
Lordship, here, altogether, Lordship, 34.960 metric tons of TMT bars were misappropriated. Out of that, Lordship, 16 metric tons were sold at Kolkata, and half of the TMT bars were in the truck. But Lordship, this person, he is the receiver of the stolen goods.
Hmm.
And in his statement, he has stated that he has sold it off to one person by the name of Pappu, whose address and information details he knows nothing about. So that is the progress.
45 days behind the bar. See, whether I have sold my party, that will give a trial. Also, length of detention, I may be allowed.
Will allow it. Heard
No,
Mr. Swensol and a council appearing for the petitioner, also heard Mr. Bishamal and a council appearing as the additional public prosecutor. Stop the FIR in this matter is to the extent that certain TMT bars which were required to be transported had not reached their destination, and a part of it was sold off at Kolkata and a part of it was sold off illegally here in illegally in Assam. Full stop. The petitioner herein is accused to have received a part of the TMT bars,
Around 16 metric.
around part of the stolen TMT bars. Full stop. Having gone through the updated case diary and the materials available on record, this court is of the considered opinion that keeping in view the length of detention, this court is of the opinion that the petitioner need not be detained for custodial interrogation any further. In the facts and circumstances, this court directs that the petitioner be released on furnishing a bail bond of rupees
Lordship, he is a resident of Kolkata.
of
Kolkata.
Kolkata. The petitioner has proclaimed himself to be a resident of a locality beyond the jurisdiction of the investigating officer.
West Bengal. Lordship, Hubli.
Beyond the jurisdiction of the investigating authority and also the competent court if he is put up on trial. In such circumstances, necessary strict conditions are required to be imposed while granting him the bail to ensure his participation in the investigation and also in the trial. In such circumstances, it is provided that इसमें वो डाल दीजिएगा वो out of territory वाला जो भी conditions है. He'll have to give two sureties, one of them a local with immovable property within the jurisdiction of the concerned trial court. He will give all the permanent addresses that he would be available in, and he will not leave the territorial jurisdiction without leave of the concerned court.
He is the resident of Kolkata.
Yes, he will have to take permission that I will be available at this point on this address. If the concerned court deems it fit, that he can go, he will go.
Got
Otherwise, he'll make arrangements here till the investigation is over. Or if you want a free stay, we can allow it by rejecting this. There's no difficulty.
All right.
Disposed.
Supplementary notice item 49.
His lordships.
Yes, sir.
In this case, my lord,
Hmm.
the intermediate quantity, my lord.
Hmm.
My lord, at the absence of the petitioner, my lord, the LS to be, my lord, recovered from the adjacent, my lord, shop, my lord. But that shop was belonged to, my lord, my neighbor, my lord. It is Noyan Mani Das, my lord.
Hmm.
That shop, my lord, belongs to my neighbor, my lord.
Hmm.
From where the LS materials have been seized, my lord. LS contraband has been seized. But at first, my lord, I would like to, my lord, at page 13, my lord, FIR, my lord. Page 13, my lord. TCR has also been called for, my lord.
Huh?
TCR has also been called for, my lord. Already.
Looks like the quantity is 2 kg, 150 grams of ganja.
Intermediate quantity, my lord. Already, my lord, 220 days, my lord.
Apparently looks like the sales sheet looks it, so subject to some strict conditions looks it. Otherwise, it is pending for evidence. It was fixed for evidence on 28th January.
The records of the trial court has been received. Heard Mr. S. Ahmed, learned counsel appearing for the petitioner. Also heard Mr. Sharma, learned APP on the question of granting bail to the petitioner. It is noticed that the petitioner, that the quantity involved is intermediate and she's a lady.
A lady, my lord. Widowed lady, my lord.
Huh?
Lady, my lord.
Lady.
Is a widow
Widow, my lord.
and has been in custody for the last
220 days, my lord. As on
120
today.
days. The stage of the stage is the stage before the land under trial court is at evidence stuff in the circumstances, keeping in view the long incarceration of a widow. This court is of the opinion that the petitioner can be granted the privilege of bail. Subject to furnishing a bond of rupees 15,000 along with 2 sureties of the like amount before the learned trial court, subject to the following conditions. Ask her not to do this from her house. Huh?
My lord.
You should not be doing this from the house.
My lord. Pardon, my lord.
She should not be carrying on these activities again during the period of bail. Huh? Disposed.
50 Lordship will kindly peruse the last order. Lordship, the CD part is not in the scan copy. For adjudication, Lordship, the CD part will be necessary.
It is submitted by the learned APP that the CD is not included in the scan copy of the trial court received. Issue fresh requisition. List again on 18th of March.
Along with the updated
Along
report
with
of the status of the
along with the updated status of the before the trial court and the scan copy of the CD. Interim protection granted earlier continues.
Funding item 34.
My lord, 38 years lady, my lord, 4
Huh?
years minor children, is in custody since 14/5/2025.
Huh.
My lord, kindly see, my lord. Page 4, para 4, my lord.
Page?
Page 4, para 4.
Page 4, para
4
4.
and 5, my lord. Para 4
Huh.
and 5. These are basically meant to crowd safety. My lord, page 5, para 5, my lord. Not, no 48 notice, my lord.
Hmm?
Only page 5, para 5, my lord.
Hmm.
Another 5, and answer 6, my lord.
Huh?
Page 5, para 5, my lord. Kindly see, my lord. Only
Why
the-
with bail application number 4125? What is there in 4125?
It is the co-accused by application, which is disposed of, my lord.
Which is disposed of?
Disposed
On what grounds?
These were the ground on Tufan Singh ground, my lord.
Huh?
Recovery was not made
Hmm.
from Manik Chandra Devnath.
And?
But here in this case, my lord, possession is there.
Okay.
But I am seeking bail on these two grounds.
Hmm.
Only the,
When you admit that you have been doing these things, do you need any further information?
my lord. This
Or your family needs any further? Yes, tell us.
We have.
This 24 hours thing, tell us. Huh? It is another matter that the petitioner took time thrice. Why you took time thrice when such good grounds are there?
This is whether the petitioner has a minor child or not, that I have inquired, my lord. She has a 4 years old minor daughter, my lord. 4 years old minor daughter.
9/2/2026 and 16/2/2026, you took time.
For only 4 years old, my lord. On last occasion, I was not there, my lord, at court.
47 and 48 is not in the
Huh?
record, lordship.
My lord, kindly see page 5, para 5, my lord. Only W2.
That is your statement.
Annexure 6, I have annexed, my lord, that W2 message.
Now, where annexure?
6,
Show us where is it?
and annexure 5 is there.
Tell us the page number, sir.
My lord, my lord. My lord, GD number page 30, page 55, my lord. Page 55. That she was left police station at 2:30
Page?
PM. Page
Annexure?
55, page 55, my lord. That I have annexed, page 55. 2:30 PM, on 15/5/2025, GD number 10, my lord. Original page 56. In record, I have black mark treatment. And by the page 57, annexure 6, W2 message, which have sent by the Nilambadar police station.
From where do you say that the seizure was completed at certain time?
Oh, my lord, this is 11:50 PM, my lord, on 14/5/2025.
14/5/25, 11:50 PM.
11:50
PM or
PM.
AM, madam.
It is in the midday, my lord.
Just a minute.
Yes.
Page 33.
Yes, my lord.
After completion of seizure, do you find the paragraph?
Yes,
At
At 2:30 PM, we arrived at the PS. So the entire procedure, earlier procedure, half an hour, traveling time 15 minutes, 45 minutes ago. 1:45. In production, they leave the PS at 2:30.
30.
So not within 24 hours, the production is not made. At page 55.
2:30 PM.
Have a look at it. I'll just come back in 2 minutes, sir. Goswami?
Yeah.
The WT message.
Page 57, my lord.
This is not coupled with the ground of arrest.
This is the receipt by the WT officer, possibly,
Lordship.
of Sri Bhumi. Is it not?
Yes.
Whether it was followed up? Again, the question.
The 48 noticing not in the PCR, so date not served.
Because here they have said that is arrested with Nilam Bazar PS case number.
Yes.
Even if this is given, we assume this is given to the family or friends. Contains no detail except the
Yes.
police case number. Is it not?
Yes, Lordship.
The time of forwarding it to the forwarding the WT is not there. This is the WT message. But will it disclose anything?
Only
Heard, mister?
the PS case number also.
Huh?
On the PS case number and other things.
Nothing is there. For recovery of which of the contraband is also not there. Whether it is ganja, heroin, cough syrup, what? They know nothing.
The quantity is used 6.5 grams of heroin.
We'll keep that in mind. And heard Mr. H.R. Chaudhary, learned counsel Payne. Also heard Mr. D.P. Goswami, learned APP. The learned counsel has drawn our attention to the different documents, certified copies of different documents annexed to the petition to assert that although the petitioner had been arrested prior to, or had been detained prior to 2:30 p.m. on 14/5/2025, the date and time of arrest has been shown as 15/4/2025 at 11:30 a.m. and that the petitioner was taken out from the police station premises at 2:30 p.m. on 15/5/2025 for production before the magistrate. It is a submission of the learned counsel for the petitioner, in which we find force that a period of 24 hours had elapsed between the time of apprehension of the petitioner and her production before the learned remand magistrate. Okay. The learned counsel for the petition has also drawn our attention to the WT message sent from Officer in charge, Nilam Bazar Police Station, Sri Bhumi, Assam 2. Officer in charge, Udaipur, Gauhati District, State of Tripura, on 15/5/20. See, this 15/5/2025, with a request to inform the family members of the arrested person regarding the arrest. This WT message, in the opinion of this court, does not contain any other detail except the police station case number and the sections under which the petitioner had been detained, and therefore does not suffice the requirements of the provisions of section 48 of the BNSS. Full stop. The learned APP has submitted that the amount of heroin, what was recovered?
Heroin.
Heroin recovered is huge, and therefore mere
615 gram.
615. He's huge. 615 gram is a huge quantity
Huge quantity.
for heroin. Is huge, and mere non-compliance of the provisions of section 48 BNSS and an infraction of the time frame for production of the arrested person before the remand magistrate cannot be ground enough to release the petitioners on bail. However, keeping in view the infraction of the constitutional safeguards available to a citizen of India who is under detention, this court is of the opinion that the further detention of the petitioner requires the interference of this court. Accordingly, it is provided that the petitioner shall be released on bail on production of furnishing a bail bond of rupees 1.5 lakhs with two sureties of the like amount, one of whom shall be in the service of the government of any of the states or the central government, and at least one of whom shall have a landed property within the territorial jurisdiction of the concerned trial court. Prior to that, you write, the petitioner has proclaimed herself to be a resident of a locality which is beyond the territorial jurisdiction of the concerned trial court. Therefore, to ensure the participation of the petitioner in the trial, this court is of the opinion that the petitioner can be directed to be released on bail. NDPS outstation conditions passport identification.
Petitioner from
That is why. Permanent address proof proof of her permanent address. And, be disposed of.
Supplementary item 51.
Here, service report on respondent number 2, what have we did?
Flag A.
It is complete lottery.
Eh?
Complete lottery.
Service is complete. No, none appears.
None appears lottery.
Although service on the respondent number 2 is complete, none appears. In such circumstances, this court deems it fit to appoint an amicus curiae to assist the court on behalf of the respondent number 2. Accordingly, Mr. Chinmoy Sharma, learned counsel, is appointed as an amicus to assist this court. The learned counsel for the petitioner shall ensure service of copy of the bail petition on the learned amicus curiae appointed. List this matter again on the 6th of March.
Let it be on 5th.
5th of March.
Lottery is fixed for framing of charge. 25th of this month. Victim has not yet been examined. Even charges has not yet been framed.
Where is the FIR?
FIR lordship will find at page lordship 9.
Where is the Caesar list?
I have not any Caesar list.
Huh?
Charge sheet I have any. Was it a medical report speaks the other way around also? Nothing.
Huh?
A medical report, lordship.
No evidence of penetration, but
Nothing, lordship.
That birth
He was examined on the same day, lordship.
birth certificate has been annexed.
that is what we are trying to see.
It has been seized, lordship, but the date I have not found.
Then again, you see, when she's a student of a school,
Yes.
School certificate.
on 5th, list again on 5th. Please supply a copy during the course of the day.
Yes.
Item 37.
Yes, madam.
Also, is my lord,
Ah,
from the FIR, lordship will find contents of FIR. There is no such ingredients of offences under section 6 of the POCSO Act, my lord. From the FIR, lordship will find. Annexure 1, page 11, it's a particular. So may I read it?
Yes.
FIR laws on 18/1/25,
Ah,
my lord.
This is looking
Uh,
anticipatory bill.
Anticipatory.
Anticipatory bill.
FIR laws on 18/1/25, my
Hmm.
lord. Stating that, my lord, the complainant is the father of the alleged victim girl. He said that, my lord, the petitioner of your lordship, he was the imam of the masjid. And my lord, he has been taking the religious classes of the locality. And that particular girl at relevant time, she was 16 years. And she accompanied with the petitioner and moved at different places, and they have some physical relationship also.
Hmm.
And when her parents came to know, and the villagers also came to know, she felt ashamed. And out of that silence, she consumed phenyl. And her father took her admitted into a nursing home. And she has been fighting for life and death. That is the allegations of the complainant.
Hmm.
From the annexure 2, Lordship will find this is an order dated 21/1/25 of the special judge. Nagaon. Here, my lord, last line, the aunt of the victim girl, Asia Begum, has filed a petition for taking custody of the victim. On being asked, the victim stated that her parents are in their home and that she has been staying in the home of her aunt, Asia Begum. The parents of the victim are alive, but they have not accompanied the victim today. Hence, also considering all aspects of the matter after recording of victim's statement, let the victim be produced before the Child Welfare Committee Nagaon to the itself for doing the needful in accordance with law, ensuring care, protection, proper rehabilitation of the victim who is children in need of care and protection by passing necessary direction to the concerned state home for women and children, Nagaon. At present, she is studying in class 10 at Nagaon Dawson Higher Secondary School. Then, my lord, the accused of your lordship, he received a summon on 3/1/26 after you gap of 1 year. So, my lord, from the contents of FIR,
Hmm.
lordship will find there is no such ingredients of offences under section 6 of the POCSO Act.
Hmm.
So my prayer is, and whether there is any medical report, everything, but that was not applied to us. I think that will be revealed in that this year, if any.
Okay, without commenting on the merits, lordship, lordship has seen summons has been issued.
No, let us see one thing.
That's why I pray for prayer bail, my lord. I have
We
not arrested
cannot-
before.
What is this? Your logot. Sangam
He is the Molana.
করে তার পিছত চলচালনা দেখি
You may kindly compare the ingredients of offences under section 6 and the contents of FIR.
Hmm.
So our objection is lordship that only summons has been issued. There is no apprehension, lordship. Investigation is already over.
The
Summons has
accused
been
made with sexual intercourse with tendency of incitement. What more do you require for section 6 at the moment?
It is not an aggravated punishment form of.
Aggravated, any minor in the custody of a person with the knowledge of the parents,
Of course.
in the opinion of this court, unless changed by proper
Maybe
arguments,
below 18
is aggravated.
Maybe below 18 years, but she was at the relevant time 16 years of age.
Huh.
So, my lord,
Child.
when someone was issued, my lord, I may kindly be allowed to go and.
He is a teacher.
Yes.
He is a religious teacher. Teacher is there, child is there, sexual incitement and
There is,
intercourse is there.
there is no specific place, time, and date of occurrence.
This should be asking too much, madam. This kind of an argument, you are asking too much. A father will say, at this o'clock, on that bed, on this car number, in the back seat, in the front seat. You want us to explain that part? We have gone through the contents of the anticipatory bail petition. Yes, you are appearing for?
As amicus for the respondent number.
Yes.
Well, apparently, my lord, this offense is made out. And the
Yeah.
Lordship has already pointed out the fiduciary nature of the relationship is there. Also, it refers to multiple instances, my lord. So it's not a single instance, so automatically it becomes aggravated, my lord. And the point which my lord pointed out, charge sheet has been submitted, summons has been issued. So application of apprehension is no longer there.
This is a summons from,
Summons has been issued. Your lordship.
summons from?
From the court, my lord.
Court.
Charge sheet has been
Why?
submitted.
Someone's from court, my lord, but he was
Investigation.
arrested, my lord.
Investigation is already over. There is no.
Then
appeal.
why the apprehension of arrest?
Yes.
This is then summoned by the
He may
court.
be arrested, my lord. That's
Oh.
why I have come before lordship. He may be
The,
arrested.
and what about the period of investigation? You were not arrested.
No, no.
Then point it out to the learned court below that during investigation I was not arrested. Why arrest me now? Go and participate.
But my apprehension is I may be arrested. That's why I have come before your lordship, my lord.
This is an application under section 482 of the BNSS, 482 of the BNSS. Bring for pre-arrest bill in connection with
Petition may be closed with observation. my lord.
under in connection with
Find it at last page, my lord. POXO case number.
that is what we are saying. This is 255.
Yes, my lord. POXO case number.
In special POXO case number 255 of 2025, which is pending trial in the court of the additional district and session judge, comma,
Special judge.
Nagaon, Assam, special judge, Assam. Stop. The petitioner has received summons from the court to appear and face the trial. If charges are framed, full stop. At this stage, this court is not of the, is of the opinion that when the petitioner was not arrested during the period of investigation, the apprehension that he may be arrested when he appears with the learned trial court has to be tested before the learned trial court by moving an appropriate application before the appropriate court, full stop. In case such an application for bail, regular bail is moved before the trial court, the same shall be considered on its own merits without reference to the dismissal of this present AB. Anticipated bail petition dismissed.
Item 48.
Please, your lordship.
Lordship,
As per last order, CD was called for.
38.
Not received, lordship, they are on interim.
The CD is awaited. Petitioners are on interim protection of this court. List again on the 20th of March, 20 of March, awaiting CD, interim protection. Continues or is curtailed?
Continues.
Continues. Continues. This much continues.
Applies a lot.
May I please your lordship, I have a small pair lordship regarding the item number 4. I have a pair lordship regarding item number 4 lordship. It was fixed on 6 March, but that time my mandatory period will be over lordship on 6 March lordship. Kindly we may fix on 2 March, 2nd March lordship. Item number 4 lordship.
Item 4, 2nd of March. But we do not appreciate this intervention when the court is
Not
running.
empty
You can
lordship,
have it
paddle,
when we sit down at 2 or maybe some other time. Huh?
lordship,
Next time, do not
lordship.
disturb the proceedings of the court with something which has already been done.
Supplementary post list, item 52.
This is.
Item
lordship,
4 to কোনে
yesterday-
লৈছিলে তেওঁক জনাই দিয়ক।
Yesterday's matter.
Yesterday, lordship has asked the learned friend to obtain instructions regarding.
Lordship, I have pointed out in the scan copy, lordship, a flag mark is there regarding the birth certificate. It has been stated to be fake. Lordship has also pointed it out because the second part of her name doesn't match. And in the meantime, I have taken instruction, lordship, that the fact that the victim was a married lady, lordship, it was never informed to the IO, nobody. And lordship, her husband was also not examined. So lordship, and there are other facts to the case, lordship, but may not be proper to disclose now, Lordship. So apparently, Lordship, there is some doubt regarding the authenticity of the FIR. Because apparently, Lordship, the absconding accused person with the lady, she had some relationship with the accused person. Absconding accused person,
This petitioner.
the victim.
Now the victim has
Yes,
a relationship with the petitioner.
not the present petitioner, Lordship, the third accused.
Ah,
Lordship will kindly see the charge sheet test case. His name is Alfazuddin. Yes. Alfazuddin is absconding.
huh?
Three accused persons are there, including the present petitioner.
Huh?
Petitioner is the number one accused. Number two is his wife, who is absconding. And third is Lordship Alfazuddin.
I'm the number two, Lordship.
Oh, yes, she is the number two. And Alfazuddin is the third accused who is absconding. She has a relationship with Alfazuddin, but in spite of that, she was married off to another person.
This is my
Lordship,
cousin, brother.
it is suspected, Lordship, that this Alfazuddin had some video of her, which was maybe circulated. And thereafter, this FIR was lodged against them also, Lordship, because they happen to be the relative of Alfazuddin.
Not Alfazuddin, Lordship.
Not the lady itself. They are the relatives of the lady
Yes,
who was protesting her relationship with Alfazuddin.
yes. So that fact is there. Now, Lordship, the husband, her husband is already behind bar.
Behind bar, Lordship.
She is approaching her Lordship for anticipatory bail because she was not present during the investigation. That is apparent, Lordship, because house search, all these things are there. In fact, witnesses have been examined who have stated that she is not residing here for the last many days, Lordship. So she could not be traced out.
Huh.
Now she is before your Lordship seeking anticipatory bail.
We will take a note of all the observations made, of all the things that have taken place, whatever has come to our notice.
Lordship, whatever I have submitted, Lordship, all those things are not before the Lordship.
No, what has been brought for us? You should approach the trial court with all this material.
The the informant is a minor who herself has filed this FIR, Lordship. Actually, also weaponized the act, Lordship, and against me, Lordship. That allegation is that I have helped my husband, Lordship.
When
And
is the
Lordship,
next date fixed?
Lordship,
When
on
is the next date? Huh?
Tomorrow the case is fixed before the learned court.
No, see, minority part is also doubtful.
And
because the
yes,
birth
Lordship, that
certificate, Lordship, is seen.
So, my lord,
We'll give her the protection for the time being. We'll allow the, we'll direct the trial court to take into account what has been stated in this petition. Cause an inquiry into those.
Yes.
And on receipt of the police report, the trial court will proceed in accordance with law whether the FIR or the documents produced or other things require a further thorough investigation before charges are framed against any of them.
But the thing is, Lordship, in this case, probably charges has not yet been.
So that is why we are saying
Yes.
that the trial court will first cause an investigation into the allegations leveled by him. The requiring the police to find out whether the birth certificate is correct, whether the
That is already on record, Lordship.
it is not correct, na?
Yes.
It is not correct.
I have flag mark, Lordship. In the scan copy. So on this basis, the court cannot, in my respect, we cannot.
It should not. It should not fall.
So that may be brought to the notice of the.
And thereafter, the allegations that she is a married person.
Yes.
And the fact has been hidden from the court, and all these things will first be inquired into the court, into by the court through the investigating authority.
Yes.
Take a report, then take a decision whether the prosecution for filing of a fake case is required to be proceeded against or not. when the entire investigation has been put into motion by.
Well, Lordship, if I may just submit.
Please.
Rather than directing the court, if all these things are brought to the notice and thereafter that decision to be taken by the concerned court regarding the inquiry part. That is my respectful submission, whether it
Then it will stay in the arguments part, whether the inquiry should be made or not. Before the trial court, both parties would keep arguing, yes, an inquiry is required, no, an inquiry is not required.
then also,
But if we request the learned trial court to take an inquiry, to have an inquiry made,
Lordship,
to find out the veracity of the
yes,
minority of the child, since the birth
Yes.
certificate produced is
and also
a
the
false birth certificate,
status, marriage status.
the marriage status.
Was not disclosed throughout the investigation. That should have been disclosed also.
Heard, Mr.
Yeah, boss.
Learned counsel appearing for the petitioner. Also heard the learned APP, Mr. B. Sharma. The husband of the petitioner had been arrested on.
On lordship.
When was the husband arrested?
14/10/2025 lordship. Page
14/10.
2025.
2025.
Page 19 lordship accordingly.
On the basis of an FIR lodged on.
Yes, lordship 15 starts.
15/9/2025, which culminated in the registration of police case, Dhing police station case number 229 of 2025, registered under section 351 within bracket 3, 127 within bracket 2, /3 within bracket 5 of the BNS, read with section 14 and 15 of the POCSO Act 2012 and read with section 67B of the IT Act. The scanned copy of the trial court records have been received. A perusal of the scanned copy of the TCR indicates that the birth certificate produced by the alleged victim, who is also the informant of the FIR, was found to be false. As per the certificate given by the registrar, birth and death, Dhing BPHC, Nagaon, Assam. The learned counsel for the petitioner has submitted that the petitioner, who is also the maternal and paternal aunt.
Lordship, maternal cousin is the person with him the lady has married, Lord. The informant has married. So
Is the maternal cousin of the husband of the informant.
no, Lordship, the informant married to a person namely Rizabul Islam, who is maternal cousin of my maternal cousin.
So you are the maternal cousin of the husband of the informant.
Informant, Lord.
That is what I said.
Lordship.
The petitioner is the maternal cousin of the husband of the informant.
Lordship.
And because she had raised objections to the, and she had earlier raised objections to the affair of the informant with the third accused,
Case number 3.
with the accused number 3 in the FIR, the informant has initiated this, has initiated the proceedings against the petitioner with a motive of revenge and harassment. This court notices that as per the scanned copy of the TCR, as per the records available in the scanned copy of the TCR, it is now revealed that the informant is a married lady. Rather, it appears that she has declared herself to be a minor, and before the remand court, an application was filed for custody of the informant by the mother, and accordingly custody had also been granted. Next paragraph. In view of the fact that the birth certificate of the informant as supplied by the informant herself has been found to be false, and there are specific allegations that the informant is a married person, is a married lady, and also the fact that the informant had herself lodged the FIR, this court is of the opinion that a request can be forwarded to the learned trial court, namely the additional district and session judge number 1 cum special judge Pokso Nagaon, to have an inquiry conducted through appropriate agencies regarding the veracity of the allegation made that the informant is a married person who is married to one. What is the husband's name?
Paragraph 8, I have mentioned, Lordship. Rizabul Islam.
Who?
Rizabul Islam.
Rizabul Islam.
Son of Amrazul.
Huh?
Son of Amrazul.
Son of
Amradul.
Amrajul alias Amdadul. You will find it.
Paragraph 8, page 7.
Page 7, para 8, huh? Page 7, para 8, huh? Resident of, huh? Page 7, para 8. Underline ko ito, huh? Hello? If in fact the informant has been given away in marriage, and if in fact she is a minor, then there are other incidents which may require an investigation whether offences under the POCSO Act has been committed by persons other than those, by persons other than the petitioner or the other accused in the FIR dated 15/9/2025. Is it 15/9/2025? The aspect whether the petitioner, whether the informant has provided false information regarding her age is also required to be gone into before the learned trial court opines to frame charges against the petitioner and the other co-accused in the FIR dated, in connection with the FIR dated 15/9/2025. Accordingly, it is expected that the learned trial court shall cause the inquiry before coming to a decision as to whether any of the offences alleged against the petitioners require charges to be framed in the given facts and circumstances as projected before this court. Keeping in view the entire conspectus of the matter, it is directed that the petitioner herein shall appear before the learned trial court on tomorrow.
Tomorrow is fixed, so
Appear tomorrow.
certified copies of order.
Huh?
And on the next date, it will be better.
Why?
I will.
You appear tomorrow.
Yes.
Shall appear before the learned trial court. Now, it has been informed to this court that the next date in the proceedings has been fixed tomorrow, that is on 26th of February.
26th.
Of February 2026, full stop. In case you don't inform again, you will have a non-bailable warrant and all that. But tomorrow, if she appears, will she have her bailer ready? If she's somewhere outside, if she's in Gauhati, will she be able to reach back Nagaon? Huh?
I'm praying, since tomorrow is the short time, on the next before
The petitioner shall be, the petitioner shall appear before the learned trial court on or before the 9th of March 2026, along with a certified copy of this order. And on her such appearance, she shall be released on bail on furnishing a bond of ₹20,000 with 2 sureties of the like amount, subject to the satisfaction of the learned trial court. And the learned trial court shall be at liberty to impose such further conditions upon the petitioner to ensure her presence and participation in the trial proceedings thereafter. Full stop. What else?
The inquiry may be conducted as expeditiously.
As
As fast as possible.
the inquiry requested by this court shall be taken up with due diligence to ensure that the facts are brought before the learned trial court at an early date. Full stop. It is needless to say that in case the allegations leveled by the informant or the information supplied during the investigation are found to be false, the learned trial court would follow the due procedure of law for initiating false cases under the POCSO Act. It is also observed that in case the allegations level, in case the petitioner herein has made false accusations, it is found that the petitioner herein has made false accusation, the learned trial court would be at liberty to take the same into account during the trial proceedings also. Both of the cases. If she is at fault, let her visit. He be disposed of. We do not know whether it is the correct procedure or not, but Mr. Sharma, someone has to start it. We can only make a request to have the inquiries made before they take up this POCSO matters against anybody and everybody. Last occasion we saw it was a 65-year-old man because of that blocking of the road. 5-year-old child goes and makes a statement. He has been touching me. And then she on the cross-examination comes up to say, nothing. I've been taught by my parents. Is this the way? Yes, sir. Huh?
The 83 application, 155 days behind the bar. The 22C is there. But my lord, I think record has come, non-compliance of 36 and 48. And competition was done by WT message. This is the information.
That 40.
Where is that?
48 and other part also, I have not found in the TCR.
It is not there. It was never given to me.
The WT message is there.
Yes, I have got the document.
Just a minute, sir. Let me interact with him because I have to hear him first. Yes.
Yes, that part is also not found in the TCR also.
And this 36 is saying? 35 or 36?
Only 47 I have found.
Huh?
Only 47 is there also. 47.
Only 47 is there.
The certificate.
Yes, sir. What did you have? Mr. Biswas, what do you have?
Message, 76 by WT message. No signature. As per WT message.
Yes, the petition was from Manipur.
Yes, not Manipur, Mizoram. Cookie.
In your petition, you have Chandrapur, Manipur. Chandrapur, Manipur.
Surachandpur.
Charge sheet has been submitted.
Submitted. But no trial has been started.
33.469 kg of Yaba tablets.
Yes, admitment. It was recovered.
Charge is not claimed yet. Next day is 24-26 for production. Last day, yesterday was the last day for production. So charge not claimed yet. There are 7 PWs are there.
But can we overlook 35C and 48 otherwise?
We cannot overlook, but they have certified copies with the but sometimes if they have
That's why it is not in the record.
But on that, I have got a line a trial court on the production order. 47, 48 compliance order is there.
Then it should have been here itself.
Yes.
Why is it not here? Swas?
I have forgot to flag my question. I have given to you.
And language used in it is English. He's a cookie. He doesn't understand English also. Ivan Kumar.
Signature of in English.
You will be burdening the arresting authority by keeping this software where anything said will be translated into a language known. Can we burden them with that? When the
47
WT is not here.
In the 47 notices, they are signature in English.
Therefore, the language we are not concerned with. But, when none has been in
Trial court order.
trial court order. Have you marked it? No? Huh?
They were restaurant 24/9/25.
Yes, 24/9.
Huh?
They were restaurant 24/9/25.
25.
Hmm. One person has been released by the trial court.
Yes,
Huh?
other co-ed is released.
By the trial court, hai na?
Yes.
The recovery is from these petitioners.
That is 6. Yes, per WT message. 42 the 47 to. That was also in English.
The session just says that case diary reveals present accused persons were produced before the learned magistrate on so and so. Further, reveals notices under section 47 and 48 were served upon the accused. How? As per WT message is all that is given. And the 48 notice is not here in the
Not
record. Now we were earlier on strict conditions.
Yes.
Now we'll have to figure out stricter conditions. Heard Mr. S.C. Biswas Learned Counsel appearing for the petitioner, also heard Mr. D.P. Goswami Learned APP. The trial court scan copy of the trial court record has been received and produced. The Learned Counsel for the petitioner has submitted that the petitioners were not served. The friend, family or relative of the petitioners were not served with the notices under section 48 of the BNSS as required under law, and therefore the detention is vitiated. Arrest and detention is vitiated. Huh? Good stuff. He has also pointed, he has also submitted that the arrest memo does not contain the signatures of any independent witness, family, friend, or relative of the accused arrested person, and therefore also the arrest is vitiated. Full stop. The learned APP has gone through the scan copy of the TCR, and though the other the notices under section 47 etc. are available, but the notice under section 48 of the BNSS being forwarded to the friend, family, friend, or relative of the petitioner is not found on record. It is also noticed that although there is a reference to the WT message, there is no assertion that the WT message had been served upon any of the friend, relative, or family of the accused. Full stop. In such circumstances, this court is constrained to hold that the arrest and continued detention had become illegal. Full stop. However, this court cannot lose sight of the fact that there has been an alleged recovery of a huge amount of contraband substances in the form of yaba tablet from the accused persons. Therefore, this court is also under an obligation to ensure the proper, it has been charge sheeted, to ensure the proper participation of the petitioners.
Day-to-day appearance, make it sure, but
Huh?
every day they will appear.
The petitioner, who have proclaimed themselves to be residents of localities beyond the jurisdiction of the trial court, is confirmed and ascertained by imposing strict conditions for their such appearance, for ensuring their such appearance. In the circumstances, the petitioners are directed to be released on bail on furnishing a bond of ₹1.5 lakhs each, with 2 sureties of the like amount, one of whom shall be a government servant serving with any of the state authorities or the central government, and one of whom shall have landed immovable property within the jurisdiction of the learned trial court. Stop. তাৰপিছতে সেই কন্ডিশন কেইটা দি দিব আউট অফ ষ্টেট থাকা যিকেইটা। Accordingly, bail application is disposed of.
So hard. They may not get all these things.
See,
I have to come before your lordship.
we are being so harsh because some investigating officer
Yes,
did
yes.
not put up a signature.
Yes.
Will we not be harsh when the entire society is at stake?
But regarding the amount, your lordship has not fixed, I think.
Yes, we said 1.5 lakhs.
1.5
2
lakhs.
sureties, one of whom shall be a state government or a central government servant, and one of whom shall have landed properties within the jurisdiction of the trial court. We cannot ask the trial court to go and ask someone in Manipur, please find out the man in this stage. Can we?
One should be government and
One is government and one should have a landed property. The government servant can have both, no problem.
both the accused are
Both,
obliged.
unless you want it only for one.
No.
You want it for both, okay, for both. Matak, আৰম্ভ কৰক। এটালৈকে আছে যেতিয়া আছে।
Orders, item 39.
এনচি দাসৰ কোনটো পঢ়ি আছে চাওকচোন। লিষ্টখন আমি আপডাউন কৰিছো।
Item 39. Also, there is an order, Lordship. Actually, I am appearing for as per number 2, Lordship, PM vigilance. The criminal appeal, Lordship. Appellant, I think Mr. BK Mahajan is there.
Action number 39, my lord.
39.
PCR has not been received, my lord.
No. The PCR is yet to be received.
Lordship.
Issue reminder. The PCR was required to be called for by the order dated 2/2/2026. List again on the 20th of March 20 March.
20 will be too long, my lord. Can it be on 11 or 12, my lord?
12th of March.
Presence may be recorded. I am appearing.
The learned special PP,
Special.
CBI,
CM vigilance.
CM vigilance is present.
Obliged.
Obliged.
Kita orders. Mr. Das, anything urgent?
Admission matter, my lord.
Item 39, Lordship.
No, we'll call for it. We just wanted to know because if we carry on now, Mr. Das will be here till after lunch. We were trying to accommodate him. Huh?
Just one copy may be provided, directed to be provided to us.
Which one? The
Item 39.
30? Yes. You have not provided any copy to?
No. We have been especially engaged in this case.
They have been especially engaged in this.
39 copy ready.
Serve me a copy.
That's obliged.
Yes, Mr. Das.
This one, item 11.
That was actually heard by your lordship, my lord, on last occasion. And on that day, my lord, the counsel appearing on behalf of the respondent, he obtained some time to provide their information which your lordship was interested, my lord. Regarding the during payment of this ex gratia compensation amount.
Yes.
My lord.
Then we'll have to take it up after lunch only. We can then try to dispose it of. Huh? It orders matic.
Item okay.
Yes, sir.
My lord, in this case, my lord, a female case was my lord.
Huh?
When the nature of dispute is civil, my lord. I'll stand to page 14, my lord.
You're prepared?
May play
Huh?
senior is on late, matter may be possible for the time being.
Page 14, kindly see, my lord.
Page 14. Huh?
Para number, my lord. Page 16, para 4, my lord. Page 16, para 4. Page 16, para 4, my lord.
Yes.
In order to, my lord, harass me, my lord, they file a criminal case against me at Golpara, my lord.
No, but they say that you have forged a signature.
No, my lord.
We'll have to hear them. She's asking for a time being. Pass over the timing, we'll have it at 2.
Hello.
Yes. Timing.
Item 41.
May it please your lordship. Lordship, we have filed our affidavit in opposition yesterday, lordship.
Hmm.
Your lordship, we received the affidavit in opposition yesterday.
Hmm.
For preparation, let the matter be fixed for next 2 weeks, after 2 weeks.
The learned counsel for the respondent has submitted that the affidavit in opposition has been filed
Yes.
yesterday. And the learned counsel for the petitioner seeks for some time to
For preparation.
file their rejoinder if necessary. Full stop. List this matter again on the 20th of March.
Oblige your lordship.
42, my lord. Earlier item, my lord, 40, seat for, my lord, it was 14, 1 poll, my lord. Seat for it was 14, my lord, 1 poll, but my item.
It's in my mistake, 14, I can number.
We'll have it at 2 only, no.
My lord.
You just kept it for 2. That given? 42.
Yes.
Ah,
That is a lordship, we have taken a step, lordship. Completed.
you have?
Taken a step, completed.
When did you take steps?
18/7,
18/7?
2025.
Case record আহিলে নেকি? Case record to আহিলে নেকি? The scan copy of the TCR has been received. Service report on the respondent number 2 has not yet been received. Petitioner to take fresh steps upon the respondent number 2 within a period of 1 week from today. Steps by speed post. Within a period of 1 week from today. List the matter again on 30 March 2026 along with service report on the respondent number 2.
43.
Yes. Huh?
This matter has come up for consideration of bail, for
Hmm?
IA, consideration of IA, lordship, and here.
I for what?
IA for suspension of sentence,
Where is the judgment?
lordship, and lordship, in this case, lordship, he was convicted for 304B for 10 years, lordship. And the learned PP also not yet filed the objection, lordship.
Hmm?
Written objection not yet filed, lordship. PP, lordship,
Huh?
objection not yet filed, lordship.
Why go for an objection? Do we have the lower court record? Trial court record ahise niki? Huh? Trial court record ahise. We'll take up the appeal. When will you be ready?
Lordship, then after 2 weeks, lordship.
Huh?
Any date after 2 weeks, lordship.
Yes, what do you say, PP? We'll take up the appeal. The trial court records have been received in the matter. The petitioner, the appellant has been languishing behind bars since
This date of judgment, lordship, 14/7/25.
since 3/7/2025 pursuant to the conviction. and sentencing given by the judgment dated 14/7/2025, convicting the accused appellant under section 304B of the IPC. Stop. Since the trial court records have been received, it is proposed to hear the matter finally on
Lordship, third week of, last week of March, Lordship.
No, it is proposed by both the parties that the matter be heard finally on 25th of March.
Lordship.
Have it on a hearing the 26th of March. Huh? 304B. Pregnant lady has been list accordingly.
44.
Deep developed.
The Jimba report was called for, that has not been received.
Lordship, matter may be time being. My senior is engaged in court number.
No time being for 1 hour. We'll take it up after 1 hour. Okay. Yes. What it?
45.
This matter may be disposed of. Very simple matter.
Criminal petition disposed of.
Already Lordship has heard the matter.
Huh?
Two similar cases are pending, one arising out of PRC, another from CR case, arising from CR case, and both are running parallelly. So very simple matter, and interim order also is passed, directing to stay the CR case. So my lord, it may be disposed of at two.
Mr. Sharma, can you go through it?
Without hearing the other side.
Huh?
Respondent is there, they have to appeal also.
Why respondent?
What do you mean, why respondent?
Lordship,
You
here-
made him a respondent. This court never asked you to make anybody a respondent. It is said that you are the master of your proceedings.
Lordship,
You initiated it saying that so and so must be heard.
two cases.
Now you are saying don't hear him. Please pass off. Please pass orders. Can we do that?
No, no.
498A case also.
498A, two sections are similarly running.
We understand.
One arising from the PRC,
To notice
another
on the
arising
respondent by just a
CR.
third week of February.
One may be dropped.
List. No.
This is
Did you take steps
Yes, yes. One
as required?
Yes.
Eh?
big steps.
এইটো দেখুৱাই দিয়কচোন 19/2 দেখুৱাই দিয়ক তেওঁ kindly see the office note dated 19/2 হ'ব নেকি মানুহখিনি ৰখাই থৈ কি হ'ব অৰ্ডাৰ এটা আছে counsel for the petitioner shall ensure that steps are taken as required by the earlier order of this court for service of notice from the respondent number 2. List again on the 30th of March, allowing the petitioner to take steps by within 3 working days from today.
46.
Should we add that if you don't take steps, it will stand dismissed?
Immediately today I will take.
Please do.
Deeply obliged.
Yes.
Your Honor, as per last dated order, scan copies are called from the lower court of Hojai. I don't know whether the copies are received or not.
Copies have not been received. That is fine. Await report, service report on the sole respondent as well as the scan copy of the KCR. List again on 23rd of March. Huh? I got a lot of says. Thank you. Thank you.
Finding item 1 and 2.
Lord, in the morning that additional affidavit I prayed for, my lord.
Yes.
That has come, my lord. My lord, your lordship.
But I was arrested on 29/1/25.
25.
29/1/25.
Hmm.
So, my lord, I am 29 days in judicial custody, madam. So, my lord, your lordship would get the FIR, my lord, at page 12. Onwards, my lord, main question is at page 14. May I read, madam? Page 14.
Ah.
Hello.
Page 14.
14 on 4.
Ah.
May I read, madam?
Hmm. They tried to break that premises. Is that case?
Madam.
With bricks, yes.
My lord, allegation in short is this, my lord, some people gathered in front of the office of the SDC circle officer, my lord,
Hmm.
and had done some mischief.
Hmm.
So, my lord, my humble submission before your lordship, my case is this, my lord. I'm principal. I'm principal of a higher secondary school, my lord. Private school. At that time, my lord, school duty was there. The examination duty was there. From 8 to 3:30, my lord. I was in the school. That is my contention.
Hmm.
So, however, what happened, my lord? My lord, as your lordship aware of, in Bilashipara area, my lord, some eviction drive is taken away by the government.
Hmm.
And in that case, my lord, my village also affected.
Hmm.
That is why, my lord, as a person, my lord, as my land was also affected. So I came before your lordship in High Court, my lord. I have filed 2 writ petitions, my lord. So, my lord, that area, my lord, most of the people are illiterate. I'm an educated person, my lord. So, administration think that I am the person leading these people.
Hmm.
So, I was targeted because, my lord, it has happened in the circle office. And my question is also regarding land these evictions, my lord. So, I was targeted from early, my lord. So, I was not present in the place, my lord. My lord, it so happened what regarding this hearing, my lord. Hearing of electoral roll.
Hmm.
At the time of SR, my lord, some objections were raised against some persons. They came to the office of the SDC for hearing. But the time was given 9. But unfortunately, no officer was available. Public gathered there from 9 itself. Up to 11, there was no person available. That is why, my lord, there was some commotion. And to be frank, my lord, when public is dissatisfied, first thing their name is struck down from voter list. Objection raised. And that also hearing is not taking place from 9 to 11.
Hmm.
There was some commotion. So, my lord, there was commotion, some people raised some slogans. Immediately, my lord, what is the real fact, my lord? What has been ground reality, my lord?
Hmm.
That was not on record.
Hmm.
Immediately, my lord, circle officer came. Police was present there, my lord.
Hmm.
Police was present there. But immediately, circle officer started to beat them by a baton.
Hmm.
And that has happened, my lord. So it was a crowd. So pelting, etc. started.
Hmm.
So my case is this, my lord. I was not present there. But occurrence has happened. Now, my lord, here one point has been raised
Hmm.
that there was a case against me earlier in the ground of arrest, my lord, your lordship will see in the
Yes.
forwarding report. that earlier there was a case, same nature of case. That is why, my lord, I have filed this additional affidavit. What was that case? That was case is of separate background, my lord. And case is suscited. Your lordship will see the additional affidavit. That case,
You actively participate in public related matters.
I related the public related matters because, my lord, on that particular day, I am not. But regarding eviction, my lord, massive eviction is here, my lord. My land was evicted. I came before Honorable High Court by filing two writ petitions by. So I was targeted. Now your lordship will see the additional affidavit, my lord. That case, my lord, FIR at page 9, my lord. Annexure 9, page 36. Page 36.
Podokia means
Podokia means
accused.
Accused.
Accused. Your translation says victim.
My lord.
Deliberate or
My lord.
misnomer.
My lord, misnomer.
The victims were identified as Sofiur Rahman. And the Assamese version says, Ullekito Podokia Krome Sofiur Rahman.
Yeah, accused, my lord. It should be accused.
Eh? We have to reject the additional affidavit.
Your lordship,
Yes.
I am referring to page 36, my lord.
We did it.
What
You have
more
taken
you
money
said?
to that you need not be evicted. We will protect you and all that.
My lord.
We will give money to the official.
The Monwar Hussain raised objection
Hmm.
that I am involved in some fraudulent activity by collecting money from the public and cheating the public. That was the allegation. And ultimately, my lord, police, after investigation, filed the search sheet, my lord. What was the case, my lord? Case was submitted, case was registered. Case was registered under, your lordship will turn to page 38, under section 316 to 318(4), 3 wooden bracket 5 BNS. Read with so and so, my lord. Now your lordship would be pleased to see the search sheet. Search sheet was submitted, my lord.
Against you also?
Against me also.
Okay.
All the named accused person, search sheet was submitted. Your lordship, is search sheet starts from 46. So, my lord, in the search sheet, just from 47 was question regarding Mong and his crime was under 7 years. Under 7 years. Below, it should be below, my lord. Translation is not proper. Below 7 years.
It is your translation.
But the Kia was not arrested.
And instead of writing
released from
Mong, you
police
could have
station
written a case number.
My lord.
Huh?
So, my lord,
Podokia Gon was
my lord.
not arrested.
Below.
Accused were
So
not
he was
arrested.
not arrested or given released on bail because, my lord, it is below 7 years. On the nature of the case, police released him. That is the case. But in the ground of arrest, my lord, now your lordship will come to forwarding report, my lord. Forwarding report.
Of?
Forwarded page 19 of the petition, my lord. My petition, page 19. Ground of arrest, my lord. FIR named accused so and so, my lord. During the same incident, the accused person and his associates caused extensive damage to the government office property. My lord, that was a mob.
That was a mob.
Mob and somebody throw tables, etc.
One of the three accused, three stone. One of the
Same
Mexicans
incident,
mentioned
accused
above.
person and his associates caused extensive damage to the government office,
Okay.
including official infrastructure records resulting so and so. That I have stated how it has happened, my lord. Now, your lordship would be pleased to see para 3 at page 20. If not accused person will surely organize a vehement protest. My lord, hearing was not done. people gathered there. The ground is this, if he is not arrested, then there will be vehement protest. Vehement protest. Again, as accused person, namely Sofiur Rahman, was previously involved in a case, by case number, so I referred, my lord, and such sheet is filed against him. So, my lord, that case, it is projected, my lord, it want to show that I am of that type of type of person. I used to create disturbance. But that case is completely separate. It is not the nature of this case is completely different than that case. That is that fraudulent, etc. That is.
He should be allowed to take up different types of disturbances.
No, but they want to say same nature. I
No,
want
it is
to
not
put
same nature, but he should also
same-
be allowed to take up different nature.
Same nature. And also, my lord, it is not a case that serious offense is there. So I was allowed to go on bail, that below 7 years only. So notice is given and I was allowed to go. Now, my lord, lastly, my lord, my submission is this, legal submission. CD is there, my lord. Your lordship will see whether the provision of section 48 BNS is carried out or not. My information is this, my lord, it is not. If that is not, my lord, then the detention is illegal. Apart from, my lord, I am 21 days. Nothing to be investigated. In the meantime, my lord, investigation is over. And I am not a person that if released, again I will protest and this, etc. That is my humble submission.
History does not say so.
Another thing is this, my lord, I am a principal of a educational institution. But that's all, my lord, your lordship will see. My learned friend with some.
Okay. Yes, Mr. Dutta.
Item 2, my lord.
And
And
you
you
said
can have a look at page 18, my lord.
18.
18, page 818, my lord. The forwarding report, my lord. Brief facts of the case, my lord. Fourth line, my lord. At about 2 p.m. on so and so, certain miscreants, namely Sofiur Rahman, number 2, Najimul Haq, that is me, my lord, and number 3, my lord, so and so village, my lord, deliberately provoked and instigated the individuals present by delivering inflammatory speeches with intention of creating unrest and disrupting lawful official proceeding. So the allegation which has been leveled against me in the FIR, my lord, that I delivered inflammatory speeches, my lord. Now, your lordship will kindly turn to, my lord, page 5, paragraph 7, my lord. Page 5, paragraph 7, my lord. Now, this is my case, my lord. The petitioner begs to paragraph 7, my lord. The fact is that the accused petitioner is a booth level worker of a political party. Being a leader of a political party, he gave a press meet in front of the Sapor Revenue Circle office regarding the harassment received by the localities in connection with the hearing relating to the notice received by the localities.
When?
From the
Well,
on that day. On the date of the incident, my lord. So this I have done, my lord. I was present there, my lord. The petition, the next paragraph, my lord. The petitioner begs to state that on the day of the incident, the petitioner had neither participated nor involved in the act of pelting stones nor abetted such act. The petitioner further denies that he had provoked or instigated by the local person by delivering inflammatory speeches with the intention of creating unrest. Now, your lordship will kindly turn to page, my lord, 11, my lord. The, my lordship will see at the top, my lord, the sections which have been registered against us, my lord. 191.2, my lord. 191.3, 190, 320. All these sections are bailable, my lord, except 118.2 and 121.2. Now, if a lordship goes to the BNSS, my lord, 118.2, my lord. whoever except in cases provided for my lord, voluntarily causes grievous hurt by any means, my lord. I have not caused any voluntary, my lord, grievous hurt. And 121(2), my lord, 121(2) also, my lord, whoever voluntarily causes grievous hurt on grave and sudden provocation. So, my lord, my understanding is this, my lord.
He must have been provoked
Provoked, my lord.
in some
My
manner.
lord. My understanding is, my lord, that 153A, capital A of the code, my lord, CRPC, IPC, my lord. Now it will be 196. That could have been attracted to. Otherwise, my lord, all sections are available, my lord. So the part which I played, my lord, I have given some inflammatory statement before the press. And moreover, my lord, the last submission, my lord, which my learned friend also relied, my lord, that I have narrated in page 6, paragraph 11, my lord. Page 6, paragraph 11, my lord. The petitioner begs to state that personal liberty is started without following the procedure established by law as guaranteed under Article 21. And considering the length of detention, my lord, today is 28 days. And otherwise, others are bailable, and those two non-bailable cases are not attracted to me. Length of detention and the Article 21 violation. If the we have notice. If the notices are not there, my lord, further submission will not be required.
We need not dwell on the further submissions. 48.
No, it is not there, lord.
Pick them up from one of the best localities, the circle officer's office.
Here I want to state here, lordship, in regard to the things, lordship. Firstly, these persons were not called for hearing. They have come by themselves, lordship.
So one of the grounds of arrest is that they had come there by themselves to create a ruckus.
Lordship.
Did you tell the family?
Lordship.
Why tell us? Did you tell the family?
Lordship, I have not, otherwise it is not, I have not found, lordship. There is no note also, lordship, regarding that, whether it has been given or not.
35 not given.
47 is also, 35 reason is there, lordship.
35 not given reason is there.
Yeah,
48 not given.
48 or 47, I cannot.
Their family ran away. Something like that.
That, lordship, because
Then
IO note is also not there, lordship.
But then allegation is of causing ruckus in a circle officers.
But the thing is that, lordship, the victim, one of the victim has stated that they also earlier also do the same type of things, lordship.
Does he say that these two persons had pelted the stones?
Yes, lordship. No, lordship, they have stated that they have instigated. But the 190 is there, lordship. Unlawful assembly is there. If their object is common object is same, they are also liable, lordship. Because the unlawful assembly is there. Otherwise, lordship, the stones.
We have seen a rubber band stretch
Lordship.
more than what you are stretching it to.
Lordship.
Eh?
Otherwise, lordship, there.
When you stretch it to so far, I say go and throw a stone, you'll go and throw a stone.
No,
and then because you throw a stone, oh, Rajesh says, can it be?
No, but lordship, otherwise he has a history of doing such kind of things, lordship.
No, he has a history of picking up money to stop the eviction.
No,
Please see the additional affidavit.
Lordship, in the victim statement, it is there.
Please, will we go by what the police has found against him or what by someone standing on the road is saying against him?
Lordship, the victim stated that, lordship, otherwise.
Innocent till presumed guilty. Victim saying is nothing. It's not to be involved in any public activities any further, Mr. Sheikh. We'll impose the condition you are not to be found involved in public related activities.
No more speech before the
Stay little private. Ask your clients to stay private.
What my learned friend there, unlawful assembly. unlawful assembly, my lord, hearing was there, they were called by the SDC. That come here.
Unlawful assembly need not be from the initial stage. They might have assembled with a very lawful intent. And then it turns into an unlawful assembly because your client gives a speech. The principal of the area gives a speech.
Unlawful assembly, it cannot be termed as unlawful assembly.
Either you undertake that your client would not participate in.
No more speech before the press, my lord.
Heard Mr.
One is
Learned
Mr.
Counsel appearing for the petitioner, also heard Mr. N.J. Dotto. Learned Counsel appearing for the applicant in to bail application number D by item number 2. The FIR in the instant case projects that the petitioners had, along with several other people, assembled during the hearing of the electoral, during the hearing of the SR being conducted on the electoral rolls, and had indulged in giving provocative speech which led to pelting of stones, thereby causing injury to officials and also damage to government property. The learned counsels appearing, the learned counsel appearing for the petitioners have submitted that while the petitioner in BA number 488 of 2026 had gone there on being issued a notice. You had gone there on being issued a notice?
I was not there. I was not issued notice. Somebody else was there. I was absent.
Okay.
I was not there.
The learned counsel appearing for the petitioners have submitted that the petitioner in BA number 488 of 2026 is the principal of a private higher secondary private educational institution in which on that particular day there was an exam going on and he was attending the examination proceedings from morning till afternoon, and therefore he was not present at the locality where the unlawful assembly had created chaos. It is further submitted by the learned counsel for the petitioner that a charge sheet had been filed against him in a matter relating to eviction proceedings in the area, and therefore the district administration had acted in vengeance against him, so that in vengeance against him, full stop. The learned counsel appearing for the petitioner in BA 470 of 2026 has submitted that the allegations were only to the extent that he had given inflammatory speech. However, the petitioner had called for a press meet and what is the term called now? Interacted with members of the press and had not interacted with the members of the public to instigate any unlawful activity within the office premises. He has further submitted that all the allegations leveled against the petitioners are bailable, and only two of the offences, both of which are in regard with causing grievous hurt, are the only non-bailable section. Full stop. The counsels for the petitioner have further submitted that in the absence of the notice under section 48 being served upon the family, friend or relative of the petitioners, the arrest and further detention of the petitioners would violate the fundamental rights under Article 22(1) of the Constitution of India, and therefore therefore the continued detention deserves the interference of this court. The learned APP has gone through the case diary, and an query has submitted before this court that there is no indication in the case diary that the notices under section 47 or 48 of the BNS had been served either upon the petitioners themselves or upon the family, relative, or friend of the petitioners. Since it is settled position in law that violations of the provisions of section 47 and 48 of the BNSS would render an arrest and detention to be illegal and unconstitutional, this court is of the opinion that the petitioners deserve a consideration for the privilege of bail. Full stop. In such circumstances, it is directed that the petitioners, namely both in BA number so and so and petitioner so in BA number so and so, shall be released on bail on furnishing a bond of rupees 30,000 each with 2 sureties of the like amount before the
As DGM M Bilasipara.
Full stop. It is further provided that the petitioners shall not engage in any press conferences or meet or other such activities which may incite public to act against the officials or government property. Any violation may lead to cancellation of the privilege of bail granted. That is the best we can say.
I'm obliged.
Anything more to be added? Shall we ban social media also? Cannot.
Item 53.
Yes, sir.
TCR was called for lordships.
Hmm?
TCR was called for lordships.
Hmm.
So is on bail lordships. Appellant is on bail lordship.
Appellant is on bail.
TCR was called for. That is not district lordship. 53, no? 53. No?
What is the sentence?
Wildlife lordship. 51 of wildlife lordship.
Huh?
51 of wildlife lordship.
No, what is the
7 years lordship.
sentence?
7 years lordship. Wildlife forest special duty to you. Wildlife police আছে না? Police আছে না? 7 years lordship.
What is the fault?
Lordship.
What is the fault?
What
What is the ground of appeal?
Unless that lordship some bone and scalp has been found from their beds by the police lordships.
Yes. It is good thing they did not take it to be human bones and skulls. They found it to be panther. Is it not?
No, lordship, actually no.
What is it? What was the skull of?
But as per allegation lordship, that is wild cat lordships.
And what is your explanation?
My explanation is that it is not found from my possession lordships.
Okay. The trial court records are awaited, but that will not be enough to secure a acquittal, sir.
And lordship, the witnesses also, my lord, could not identify lordships.
Huh?
The witnesses also could not identify as lordships. I have annexed some witnesses, the person of the witnesses lordships.
Who are those witnesses? Huh? Have you annexed? Where?
In IA lot.
Nothing annexed.
IA bail lot.
Huh?
IA for
We'll
bail.
take up the disposed IA for consideration of the appeal.
No, no.
Await the trial court records as called for by the order dated 1/12/2025. List again on 30 March. They are on bail. 30 March.
I'm being attempt 40.
My lord,
Hmm.
against this, my lord, at page, my lord, 16, para 4.
Notice is not returned, sir. Notice is not returned. Service of notice.
I've taken steps, my lord.
I think you should take your steps again.
My lord,
You'll have to take a fresh step.
my lord, I've taken.
It was taken in 2024.
My lord,
It has not come back.
My lord, 11.
No post office will be able to trace it, sir.
My lord, 11/3/2024.
No post office will be able to trace it out.
My lord.
You want the things to hurry up? Just a minute. As agreed to by both parties. Someone appeared.
Well, actually, an RF is pending here, my lord, and
Huh?
that case, my lord, we appeared for consolation, my lord. In that case. RF number, my lord, is 87 of 2019, my lord. The consolation failed, my lord.
The steps taken on the respondent number 1 and 2 have not been fruitful since there is no service report. Neither AD card has, since there is a report that neither AD card has been returned nor unserved notice has been returned full. The Lord counsel for the petitioner has prayed for and is granted 7 days time to take fresh steps upon the respondent number 1 and 2 to speed post. Full stop. List the matter again on 1st of April. 1st of April with service report.
Okay. 44. Appellate donor.
Yes,
Partner is engaged in another court.
but you are free. Tell us.
See.
You are free. Why not tell us?
I'm sorry.
He was saying that my senior is engaged in another court. I said he was free. Yes.
Well, it's a rejection of a Jimma order, my lord.
Ha.
That your lordship will find at page 31, my lord.
Hmm.
Paragraph 7, page
Hmm.
We have
31.
not received, Lord. We have not received report.
The Jimma report is awaited.
PCR partition.
Okay, Jimma report to put.
Report will be the same, my lord. Page 31, paragraph 7, my lord. It is submitted by the Learned Legal Council. The petitioner Raja Kali is the registrar of a Swift to and so vehicle, my lord.
Hmm.
Now your lordship will see, my lord, the operative part, my lord. It was rejected. Page 35, paragraph 13. In the above facts and circumstances of this case, when it is alleged that the vehicle was used for escorting in safe transportation of the seized contrabands and the owner of the said seized vehicle is also an accused of this case, this court is not inclined to allow the Jimma prayer. Accordingly, the Jimma prayer is rejected.
Yes.
Well, I am relying that apex court judgment, my lord.
Saying that it should be released,
It should be released.
but then,
That Bishwajit Day case, my lord,
Huh?
the case which goes from our high court, my lord.
the Biswajit Day has been discussed in a more recent case.
Yes, my lord, that.
Where it has been, where some conditions have been changed.
Yes, my lord.
In the case of number 1 and 2, it can be released, 3 and 4, it cannot be released, something like
Yes,
that.
ma'am.
Biswajit Day has been discussed in another
Discussed,
case.
At the end, my lord, it says, my lord, the vehicle should be released, my lord.
No. In that it says that vehicle may not be released in
Yeah.
certain cases. That is what I'm saying.
My lord.
We were given that judgment a few days ago by Mr. Sharma, if I'm not wrong.
Yes, my lord. But
Is he there? Yes, you were there, na? There's some other judgment after Biswajit Day. Huh. Four, yes. Huh.
And the latest judgment is, my lord, Denash, D-E.
Denash, yes.
Denash versus State of Tamil Nadu.
Hmm.
That judgment I could not take out, my lord. If a lordship pleases, my lord, tomorrow or day after tomorrow, my lord.
Day after tomorrow.
Okay.
Because somewhere we remember that if it is used in the trafficking
Well.
and if the owner or the driver himself is involved in that transaction, then the vehicle is not required to be released. If it was taken on hire, somebody misused it,
Well.
then the owner can take it back.
But here the scenario is different.
Here he was carrying, he was.
I was the owner of the vehicle, but
And-
I was not driving that vehicle.
But you ran away, is what they say.
No, the allegation is that, my lord, I am driving another car, my lord, escorting the car.
No, that Tata mobile, the Tata vehicle was being driven by someone else.
Yes, my lord, because
This vehicle was being escorted.
because the owner is some other person.
Have a look at the Denash judgment.
Denash judgment, my lord.
We'll have it day after tomorrow.
Friday, my lord.
On Friday, huh? Release the matter again on Friday at the request of Mr. N.J. Dotto. Learned Counsel paying for the petitioner to place before this court a recent citation of the apex court.
I'm on.
Huh? Day after tomorrow, kuch. Friday.
All right, listen, item 11. Matter was heard by your lordship, my lord.
Yes.
They kept responding and he took time, my lord, to obtain instruction, my lord. That order, my lord, order 6/2/2026, my lord, passed by your lordship, my lord. 6/2/2026, my lord.
You remember?
On the last occasion also, he didn't appear, my lord. Today also he is found absent, my lord. The counsel paying on behalf of the respondent, Chaudhary, SP Chaudhary, my lord.
Here he was working as a canteen operator or something.
No, constable, my lord.
No, he was given the duty of a canteen operator or something.
Working in the canteen, my lord.
He was in the canteen. He used to stay outside with due permission.
Permission of the authority.
With due permission, and then when he was at home,
My lord.
he suffered a stroke.
No, struck, initially it was started in the office, my lord, while he was attending his duty, my lord. Now, first of all, this, the annexure 3, my lord, I am referring to your lordship, my lord, that your lordship will find a page 26, my lord, the relevant person, my lord, at page 27, my lord. As the disability of the incumbent arose out of the official duty, as such, he will be entitled to disability pension and other benefits, my lord. That especially it was mentioned, confirmed that he suffered when he was attending to his duties, my lord. It's especially it was.
We were on that CCS extraordinary pension rules, hypertension leading to stroke, ischemic stroke and all that. Yes. Hemiplegic.
By annexure 5, my lord.
Intracerebral hemorrhage.
Annexure 5. That you, page 33, my lord. The reason by which my petition filed by the
They want to say when the stroke happened, you were not on active duty.
Well, that is the finding, my lord.
Where is the question of active duty?
Well,
it has to be during the course of his duties.
Duty, my lord. At page 33, my lord, last paragraph, my lord. Accordingly, you are hereby informed that you.
So what is his disability percentage now? What is his disability percentage now, sir?
It is 87, my lord.
87.
Yeah.
Round off to 90, 87, huh?
Mm-hmm.
Huh? You try to write it
Page
up.
21, my lord.
Huh?
Page 21.
Page 21.
21, my lord. The percentage of disability due to a disease later by
87%.
is illness is 87%.
The matter was directed to be listed for an attempt to be made to dispose of the repetition since the matter had been heard extensively. On the prayer of the learned CGC to address this court on the provisions of the CCS extraordinary pension rules and also on the office memorandum which related to the aforesaid rules, comma, this case was directed to be listed today. Full stop. Then the matter is called upon on two occasions, comma, none appears for the CGC. Hearing concluded, judgment reserved.
May I please, the revision is against the charge sheet matter filed by the court below. My lord, what happened here? There was a fire broke out in a house where my mother was there, and I was adjacent house, and my mother has lodged the FIR with delegation that it was I who set the fire. Then, my lord, another FIR lodged by another person of that same place. They have given a narrated a name of several persons had set the house. So two cases were registered. But story is different. There are, in first affair, there are only two persons, myself and my father-in-law. The grudge against me that I have married a lady against the will of my mother and living with the father-in-law, as God you it is mentioned here. Then, my lord, other, whereas because of the fire, other person also affected, he has also lodged the affair where it has been seen that I take your lordship to that FIR is.
Respondent number 2, have they been served, sir?
He has filed objection also. Your lordship will.
He has filed objection?
He has filed affidavit, my lord.
Okay.
That FIR your lordship will find as annexure number 2, my lord. So there are the difference in both the FIR. However, court has given, the police has given charge sheet against the first FIR, against me, by giving final report to other FIR. Where then a case was filed before the court below, the CR case was filed, giving the narration of the story, which was forwarded by the magistrate to the OC for investigation, which cannot. And there is a bar under 156(3) without following 154 or 55 CRPC, that they must know that whether any FIR was lost, even required to file a separate. If OC refuses to file, that in their affidavit they have admitted that the police has refused to accept the FIR. We have filed it CR case and got it forwarded to the police station. So that case was dropped, final report. But the case was filed, but there is a difference in both these stories. Regarding
by the same person, both were filed by the same person.
Two persons. But
two different persons.
Incident is same. Incident is same.
Maybe. Both had their own stories.
He also affected, my lord. The other person who has filed the FIR. So, my lord, there is a gulf of difference between two FIR. So, my lord, I have taken the plea, my lord, page 14, your lordship will find, the CR case was filed. There are 7 persons who have come to set fire. Page 14, page 100, my lord. Annexure 14.
Page 100.
page 100. Share case, but my name is also there, no doubt. My father-in-law's name is also there, but there are 7 persons.
Abdul.
But it was taken to the police station, my lord, and registered a case under section 201. My case was 20. But the FIR, my lord, your lordship will kindly peruse the FIR lodged against me.
Sir, there were different complaints made. In one of the complaints, a charge sheet has been filed.
Yes, in my case,
What is wrong?
Charge sheet has been filed, my lord. Your lordship will find.
No, whether all these complaints which have been filed and where the final report has come and all that has
That was
happened.
ended in final report.
All that are matters of record before the trial court also.
Very true. Because
Then when it is put up for the evidence, all this can be proved. Now, if there is a charge sheet against
I
you,
don't know what was the statement given by the witnesses in other case, which was ended in FIR.
now thing is that if your case has been charge sheeted, if the trial court prima facie finds that it needs to be tried and frames the charges, what is wrong?
Was issued, my lord. Against someone I have come.
Charges have been framed.
Cognizance was taken. Cognizance.
You have been called.
Yes.
You have been called to explain.
Yes, as an accused, my lord.
As an accused, you will be explained that this is the charge against you. What do you have to say? Then you may have to say that yes, this is.
Immediately after the occurrence, I was taken to the jail. I was enlarged on bail by the court below. After the charge sheet was filed against this charge sheet, my lord, I have come before them.
The charge. In which conditions can we interfere with a charge sheet?
My only condition is that there are 2 contradictory FIR. In one FIR, Sear case, they are afraid that the police will not register a case. In Sear case, they have given the name of the 7 persons. That they came and set fire and fled away. But the FIR which was charge sheeted by my mother, I am a son, has informed that 2 persons, myself and my father-in-law, came to set fire. That is because of my strained relation with my mother. Because I married another girl.
Therefore, she excluded the other 5. But that does not exclude you.
Yes.
Had she excluded you, either of the FIRs, we would have understood that yes, the story is something different, maybe something different. But here, both the parties, they include you.
In the other FIR also, our name is there. My name, my father.
So therefore, under what circumstances can we interfere when a charge sheet is submitted or charges are framed? When can we interfere? What are the conditions?
My lord, your lordship has raised a very important question, no doubt.
Otherwise, this may not be correct. This may not be correct. Will be a ground for us to interfere in any of the charge sheets being filed.
Would you believe that being a son, I will set fire to my mother's house?
We are finding it hard.
My house.
We are finding it hard to believe that your mother would falsely accuse you.
Now, in the affidavit, they said if he come to me to apologize, and I will withdraw the case. In the affidavit, they say if he come to me.
That was the first thing you should have told us. Where is it? Where is that sentence?
I am giving affidavit, my lord. I am giving the affidavit, my lord. Showing they have filed the affidavit, my lord, in which they have said, man,
go and say sorry.
In the affidavit, they said that, my lord, I take you to Para. Para, my lord, 45, can you see page 45, my lord? 41, my lord.
Para 30, page 38, para 11. Yes, I think you should go and say sorry.
Yes. Yeah, if he comes,
you should go and say sorry. You may be the eldest son, the strongest son. Be a little weak before your mother. Go and say sorry. Have it recorded that I have said sorry and she has forgiven.
Such a heinous crime. Can it be absolved by saying sorry?
We can close criminal proceedings if both the parties come to a compromise and we see very little chance of conviction. When it is a family dispute, we can close it, definitely. Why don't you go say sorry and come back? The matter is over. We cannot say sorry. You cannot say sorry. He has to go and say sorry. The mother should have some.
The other side is not there.
Eh?
Is it required other side? No, maybe required because they have filed, they have contested, they have filed the affidavit.
No, they have not contested. They have said if he comes, if he had said sorry, we would have dropped everything.
If you say like that in the court that then we
It's on affidavit. That will be the statement of a counsel. We have it on affidavit.
Yes, yes. Then my lord,
So the mother must be ready.
your lordship can dispose it with this.
We cannot dispose it of.
That is the matter.
We cannot dispose it of. You must come back and
If
tell
you
us.
submit that as per the affidavit that yes, if he apologize before mother.
No, you first apologize. Let us see whether we can close it on that line.
My lord, if I apologize, I have to swear an affidavit that I went and apologized.
Your word would be enough.
Then all right.
Your word would be
I'll
enough.
this matter to
You
my-
come back and tell us, yes, apologized. And she has forgiven. We'll send it to the trial court where the mother can appear, the son can appear, and both can stand up and say, yes,
Yes, my lord,
sorry,
I'll
sorry,
do.
done,
All I'll do.
and closed.
It come after 2 weeks, madam.
Bringing them here will be difficult, but we can have them appear
Yes.
before the trial court.
True.
And then we can exercise our powers after the statement is recorded.
Exactly. Otherwise,
Yes.
true, wait, my lord.
At the
Not
request of,
comfortable matter.
at the request of Mr. S.C. Biswas, who has submitted that an attempt would be made to have the contesting parties appear before the learned trial court to seek a compromise, since the contesting parties are mother and son, and affidavits have been filed before this court that the mother is ready to forgive the son in case he asks for forgiveness, list this matter again on the 30th of March.
Yes.
Stop. The contesting parties shall be at liberty to appear before the learned trial court and file petitions, if they are so advised, to bring on record the compromise arrived at between mother and son who are the contesting parties. Yes. Bring that back. We'll exercise our powers.
May it please, your lordship. For the respondent, your lordship, the counsel for the petition. This matter was sent to the for mediation, your lordship. Accordingly, an agreement was reached. There is a concurring finding with respect to a case under the Negotiable Instrument Act. Unfortunately, no payment has been made till date. He's been convicted and sentenced for a period of 6 months and to pay a fine of rupees 11 lakhs. There was an agreement, your lordship, in the mediation. That agreement has not been.
They did not agree to it.
No, the agreement was there, but he has not paid anything till date. So the matter will be hard and it may be disposed of, your lordship.
No, but since he agreed before the mediation center, since he is absent today, since this
Your
court
lordship.
does not feel that this is a bona fide litigation pending, we dismiss it.
Yes, your lordship.
Huh?
Yes, your lordship.
This only seems to be a delaying process.
Yes, your lordship.
None appears for the petitioner on call. The learned APP for the state and Mr. T. Deary, learned counsel for the respondent number 2 are present. This criminal revision petition is referred against the order dated 12/12/2023 passed by the Sessions Judge Kokrajhar in criminal appeal number 21 of 2022, upholding the judgment and order dated 1/11/2022 passed by the subdivisional judicial magistrate Gosaigaon, convicting the petitioner under section 138 of the NI Act in CR within bracket NI case number 03 of 2019. By the order dated 22/7/2025, this court had recorded as follows. You take from paragraph 4 and 5 of that order, huh? Paragraph 4, 5, 6, 7, 8, 9, 10. Huh? Full stop. The mediation report is available in the records of this case. As per the mediation report, the petitioner and the respondent number 2 herein had come to a consensus to the following effect. Huh? This mediation report logot deed of settlement ekhon ase. Tare now parties agreed as followed believe. Third and second page kono pa ase. Moi pencil rongai di tick mark eta digisu ha. Today none appears for the petitioner. The original judgment was of the year 2000.
22, your lordship.
2022. And the appeal was disposed of on
The appeal was this on 15/12.
2023. This criminal petition came to be filed on 16th of February 2024.
The appeal was disposed of on 15/12/2023, your lordship.
Correct kori lok ha. There is no stay operating in the matter. The petitioner was also unrepresented on earlier occasions. This court is of the opinion that the petitioner has not been, is not interested in pursuing the litigation. Rather, the attempt is to delay the payment of the compensation amount to which the respondent number 2 has already agreed to. Full stop. However, this criminal division petition being not prosecuted is dismissed.
I'm very grateful, your lordship.
Yeah, 15.
May I please, lordship?
Yes, sir.
My lord, this petition for quashing of a complaint filed by the respondent number 2, my lord. Here, my lord, the petitioner before lordship is a wife and she filed a divorce petition before the district judge Vishwanath Saryan. And after filing that divorce petition, they try to reunion. And on that situation, mutual understanding on the consent of the respondent number 2, the petitioner withdrew that divorce petition. And immediately after withdrawing that petition, again, we have aggressively and subsequently filed the second divorce petition, which is pending till date by the petitioner before you, lordship. Why? And after filing that second divorce petition, the petitioner filed a complaint before the SDGM Gauhati.
Saying? Saying what?
Saying that some documents kept with the petitioner.
What documents?
It is stated in
identification of the documents.
It is stated in the
complaint.
That is page 14. Motorcycle RC, driving license, Aadhaar card, PAN card, voter ID, SBI passbook, UCO bank passbook, cash rupees 5,000.
Give back the cash. Others he will take for photocopies. Apply for duplicate copies and give it to him.
Yes, my lord. I have no objection as because my lord.
Yes, sir.
Yes, what about my friends? What about my lord? What about? We had now I am almost 62, and my friends is 54.
55.
55. We have got a son of 29. I am looking after the girl to marry my son. In this situation, my lord, she has left my house. She is a master degree holder, serving in the higher secondary school. I am also serving in the higher. Nothing. It is an ego problem between two persons. The Honorable Court tried to bring them to court for mediation, but both the parties declined to appear.
It is
That is
already,
also another ego. No, I will not go to the court.
it is already issued and sent the proceeding before the mediation in Bishwanath Sareli.
Yes.
Nobody appeared before
Nobody
the mediation. And petitioner herself tried to appear, but
Respondent,
respondent not
very
appeared.
egoistic person.
No, but
Finish
you have
the
not
game.
appeared. You have not appeared, brother.
Came here, no problem.
No, I came. You have not appeared.
No, yes, appeared, but
Are you married to each other? No, let us not have it here.
Now
We
what
will
is-
not have this here.
But I can
Huh?
my wife at this day, where I go.
Hmm?
But she is reluctant to come.
She does not
There
want
can be
to.
divorce petition filed by her.
Divorce is only a legal procedure. Staying separate is choice.
These days, life partner goes, what will happen to me? What will be position of my society? What will be position of my son? I cannot get meet my son
Why?
because of this problem. He is
But that-
divorcee.
Nowadays, you don't have to look after the sons and daughters.
The village.
They arrange.
It is very
They
difficult.
they arrange.
That is
They
male society.
they arrange. They will arrange. And then there is another thing, Mr. Biswas, it is called to each his own burden.
No, my
Everybody has to carry their own burden. Huh?
regarding the document that she has kept
Huh?
under her custody,
Huh?
may be returned, my lord.
these are
Do you have those documents?
no, my lord. These are
Then how you do,
wrong-
how?
wrongly stated, my lord, and he left the house prior filing the divorce petition, living with his elder brother.
My passbook with my license is with you, everything with
Nothing
you.
with me.
Then where from I will get?
And my lord, very interesting, my lord.
We will pass an order whereby we shall give you the liberty to approach the bank authorities for the passbooks.
Any document is
Duplicate,
any duplicate book.
Duplicate. You can apply for duplicate passbooks. You can apply for the copy of the voter ID. Then you can apply for the duplicate copy of the PAN card. You can apply for the duplicate Aadhaar card is, sir, you just give the number, they give you a colored copy, a printout and both sides laminated.
I think matter may remand back to Larnet Magistrate, he will do all these things. I think you should not object.
my lord.
What is your prayer?
My lord, my prayer
For
is this,
quashing.
Quashing of what? This complaint?
This complaint, my lord. As because it is totally civil nature of case, my lord.
No,
I'll
not
decide.
civil nature. Why? You have kept, you will keep my document.
Keeping someone else's document, whether it has been done or not, you will be facing a trial.
Yes.
Let us assure you. We are not interfering on the ground that it is a civil nature case. Sorry. Keeping someone's identity card, keeping a registration card is not civil nature. We are dismissing this revision.
My lord, no any document kept.
Convince us, try and convince us otherwise, but let us tell you, if you are trying to make the water muddy, we'll ensure a filter is put up. We may be smiling here, trying to bring around a consensus and trying to have, but we are not entertained. And we do not like to entertain these kind of things that when he says that some documents have been taken away, you would come and say that this is a civil nature, this is theft. And whether it is theft or not, let the criminal court try it out.
It is
Go and face the trial, prove that you never took them, you never had access to them. He will lose the case and he will go home. Finished. Why don't you prove it that you never had it there?
but my lord, theft is not alleged, my lord, here.
What is alleged?
It is my lord.
Dacoity. That you kept it forcibly.
It is in the FIR alleged, my lord, here.
341, 3290, 506,
It is
111,
in the complaint.
406 is there.
It is on the complaint, just inserted those.
You are illegally retaining his documents.
That's why 406
When
is
face
there.
the trial.
Let
Tell
us
us.
go back. I assure you, we will sort out the matter before the trial. I assure you, Lord.
Yes.
What more required?
We will give him the liberty to apply for the duplicates.
নহলে আৰু তাতেই শেষ কৰিব। উপায় নাই আৰু। No, naturally.
Not the way. These are not things to be brought up in criminal petitions. Think about those
restrain
62-year-olds,
the relation more.
54-year-olds. They might have all the anger in the world, but yet they had a child.
child.
So at least 29 years ago, they were not so angry. Is it not?
My lord,
You have a child, you cannot be angry.
my lord, child, both the child already appeared before the trial court and adduced their evidences and I annexed
What?
those. Daughter and son.
Against you or for you?
For me, my lord.
Huh?
For me, my lord.
Huh.
Court call them.
So let the trial go on. Let the trial be finished.
Then she'll be acquitted automatically.
And
Yes.
Everything settles.
Yes.
You'll be acquitted. Why worry?
in my petition.
Any stay here?
Yes. Yes.
Is there any stay?
Stay is not there.
But there is no state, there is no state. But trial is not going on there.
Huh?
Trial is not going.
Why?
Because of these pendings in
I
there.
heard Mr. So-and-so learned counsel appearing for the petitioner. Also heard Mr. S.C. Viswas learned counsel appearing for the respondent. Release this matter again on 31st of January, 31st of March. Full stop. It is made clear that there is no stay operating in this matter, and therefore the trial court is at liberty to proceed.
My lord, the 2nd of April, my lord.
2nd of April, no problem. Go and place this order, Mr. Viswas.
Yes.
Have the trial continued, let her be acquitted, you apply for your duplicate copies.
Obliged.
Yes, sir.
My lord, in this, during the pendency of the matter, the certain development has taken place in this matter, my lord. And joint affidavit we have filed, my lord, and we have settled our dispute amicably, my lord. 1225, my lord, joint affidavit.
The learned counsel for the parties have submitted in consonance
Yes.
that the differences between the parties have been sorted out, and to that effect, a joint affidavit has also been filed before this court on the 5th of December.
Yes.
2025, full stop. In view of the settlement arrived at by these parties, and since there is now there is now little or no chance of the trial court of the trial being adjudicated in any manner, this court deems it fit to close the proceedings in CR number
CR number, my lord, 553 of 2024.
553
/24
2024.
Under section 498/326 and 35 PC.
Eh?
Paragraph
Pending.
9 of my.
No, you have to go a bit slow. She's taking it down.
Sorry. The my lord, CR case number 553/2024 and under section 498A/326/34 of IPC.
Pending in the court of land.
Pending before the Larded Judicial Magistrate First Class 2, Karimganj.
Okay. The parties have expressed their, another parties would be at liberty to take up such appropriate procedure in law as have been, as the wish expressed in the affidavit, joint affidavit filed before this court. There's some reference to some divorce divorce.
Already decree passed.
My lord, divorce already done.
Oh, then you can delete the last sentence. Yes.
Obliged.
My lord, it is disposed of.
Disposed of.
Deeply obliged.
Please, your lordship.
Yes, sir.
My lord, the petitioner agreed by the proceeding. An order dated 23/5/2025. My lord, at annexure 8, my lord.
Annexure 8.
Next.
No.
Next, sir. My lord, the basic case of the petitioner is that, my lord, it is a civil dispute, my lord. The respondent purchased the possessory right of a particular plot of land from the petitioner, my lord. possessory right. Only she purchased the petitioner, not the petitioner, the father of the petitioner purchased the possessory right, right of a particular plot of land from the petitioner, my lord. Petitioner, and that sale deed, your lordship will.
That Exonia Mati
Yes, my lord.
deal, huh?
That was a government land. So that was a sale deed, my lord, which was not registered because it was a government land, so it could not be registered. So she, the father of the petitioner purchased the possessory right of that particular plot of land from the petitioner, my lord. Subsequently, there was an eviction by the government, my lord, and she filed a FIR before the concerned police station.
Where is that sale deed?
Sale deed, Annexure 1, my lord. Page 13, my lord. That
Page
is the
15.
method English version. And 15 is the vernacular original, my
So জমি দখল।
দখল মাটি বিক্রি পত্র।
মাটি দখল বিক্রি পত্র নহয় না। দখল মাটি বিক্রি পত্র।
Yes, my lord.
হ্যাঁ, it is not মাটি দখল, it is দখল মাটি।
দখল মাটি।
So মাটি is being sold.
Yes, my lord.
Or the দখল is being sold.
দখল মাটি, that the
The
land
মাটি is sold.
Yes, my lord.
য'ত দখল আছে,
Yes,
সেই মাটিখিনি বিক্ৰী কৰিছো।
Yes, my lord.
So the mati is being sold, not the dokhal.
No, the possession is also being sold, my lord. Because, my lord.
The moment you say that you have sold the land also, if the land was government land, how could you sell?
Yes, my lord, that cannot be sold.
Huh.
Because it is.
So that is what they are saying, that how could you sell government land to me, to my father?
We can sell the possessory right, my lord.
If you have one.
Possessory right.
Did you have a possessory right existing on that day?
Yes, my lord.
From where do we see that?
My lord.
That you have the possession.
Yes, I propose.
Or a possessory right.
Yes, my lord. I propose to sell my 1 katha land which was in my possession.
ৰাজ্য জমি দখল বিক্ৰী পত্ৰৰ মিডিয়া আজি মোৰ টকাৰ বিষয়ে অৱশ্যে কৰা মই চুক্তিপত্ৰ কৰা এক কথা জমিৰ দখল বিক্ৰী কৰাৰ কাৰণে প্ৰস্তাৱ কৰাত খৰিদ কৰিম বুলি সন্মত হয় উক্ত জমিৰ উচিত মূল্য কৰি আজি সমুদ্ৰ টকা বৰাবৰ পৰা who bought this land?
This is the mother of the petitioner.
Where is the mother?
Mother is still with the petitioner, living
And-
with the petitioner, but the FIR was lodged by the petitioner, that is the daughter, Pompey Bora.
Then
Saying that she has cheated the
Yeah, yes, my lord.
mother of the petitioner.
Yeah,
The mother of the petitioner is cheated, she would come up with a grievance.
yes.
Why should the daughter come up with a
one
grievance?
And then, my lord, the last line of this paragraph that your lordship has read just now. উল্লেখ কৰিব পাৰি যে সৈঞ্চ তাৰিখে বাইনা পত্ৰ কৰি সমুদায় টকা পৰা 3 লাখ টকা বুজি পাইছিলো আৰু বাকী টকা আজি সম্পূৰ্ণ বুজি পালো লিখিতয়ে বৰাবৰক 23/4/2000 ইমান তাৰিখে খাস দখল সমজি দিলো আৰু বৰাবৰেও কোনো অসুবিধা নোহোৱাকৈ দখল বুজি ললো
Which page? Which page?
Page 16, my lord.
Huh.
Page 16, first paragraph, my lord.
দখল বিক্ৰী কৰি জমি মই ইয়াৰ আগতে Yes, the dokhal was sold. The government pays back the dokhal. Where is his cheating?
My lord, the land was sold to me,
To your mother.
to my mother. And immediately after getting the possessory right, I was aware, there is no denying the fact that I was not aware about the possessory right. I paid him rupees 5 lakhs and then I bought this land to build a house upon that. Immediately after purchasing this land, I got evicted. I never was able to enter into the premises for a single day. Now what happened? After I purchased the land and this thing happened, I was not well. So what happened? since the petitioner herein are a very close friend of the daughter. Actually, why that the Pompey Bora, that is the daughter of the petitioner herself, is a best friend of the respondent number 2.
Petitioner number 2.
Yeah, petitioner number 2, and they were close friends since they were in college. They studied together, they used to share the same room like that. On the faith and trust, she purchased the land from petitioner number 1, who is the husband of petitioner number 2. So after getting evicted, they approached them. What happened actually? Did you deceive us? They denied
Caveat
entirely.
emptor, madam, caveat emptor. Buyer beware. This is land. Land has its own revenue records. If the revenue records show it as government land, someone comes and tells you buy the possession from me. It is in a language which you well understood Assamese.
My lord,
Possession is sold. That possession is taken back by the government. What
yes,
else?
I was never handed over the possession. That is one part. And
Your signatures are here.
yeah, no, on paper I got this land, but physically I never got the possession. Apart from that, I lose the hard-earned money.
লিখিতঙে বৰাবৰক তাৰিখে খাস দখল সমজি দিলো আৰু বৰাবৰৰ কোনো অসুবিধা নোহোৱাকৈ দখল বুজি ললো। বিক্ৰীদাৰ আৰু কিনোতা দুইটাৰে সহি।
My money was taken with deception.
Tomorrow someone sells you 2 kilos of mango, saying that is seasonal mango. You buy them, knowing it is not the season. Then you go and file a criminal case. Non-seasonal mangoes sold as seasonal. Can it be a criminal case, madam?
No, my lord, I filed the FIR against not only the petitioner number 1 and 2, lots of other people were also involved for cheating and fraudulent. Later,
Cheating and fraudulent is when you are given a different story. Something which is not, you are being made to believe it is. You are buying Exonia Mati. What is
Yes.
Exonia? For one son, government gave you, for 1 year, the government gave you a permission to utilize the land because you have nothing in the revenue area which can sustain your life. They give it to you for 1 year. Then that 1 year continues and continues because the government is not asking it back. For that 1 year, some revenue is taken from you. You continue paying that revenue. The government does not interfere, it is getting some money. They keep quiet. But it was for 1 year. Now someone comes and says, okay, I will sell you the dakhal, that right to occupy the land. Can he?
that is
That Exonia Potta itself says that it cannot be sold or transferred.
my lord, that is another aspect of the civil dispute. I agree. But what I am relying upon is that I was deceived with the amount of money that he took away by showing us that you will get the possession and you can build upon a house thereupon. So that is where we approach the
What are the particular offenses?
Another aspect.
What are the particular offenses you are alleging him
The
of?
petition, complaint petition at page 35, annexure 6, madam.
Just a minute.
So it was a Naradi petition, my lord, because the search sheet was filed, final report
The
was
final,
filed,
yes.
saying that it is a civil dispute. So against that, the petitioner filed a Naradi petition at page 35, madam. Page 35, annexure 6. And final report, your lordship will find at page 31.
Final report was submitted by the concerned Gorchuk police station after a period of 10 years approximately. After a period of 10 years. In 2013, the FIR was lodged, wherein the final report was submitted by Gorchuk police station in the year 2023. So after 10 years, she waited and for some response from the police station also, but nothing happened. Then she
applied for through the Narazi petition before the learned trial court below. And the impugn order, I have a submission on that on. The impugn order 23/5/2025. Actually, the impugn order should be 11/3/2025, wherein the cognizance was taken by the learned court.
No, 23/5/2025.
Now, what are you saying?
Page number 70 and the page annexer 1 of affidavit. It is on 11/3/2025, where the precognizance hearing was taken by the learned court. Court. And the cognizance was taken on that particular day itself, 11/3/2025, not on 23/5/2025, based upon which this entire petition was filed. The second part of the order says, I have heard learned counsel for Nakibul Rahman and Zili Uzair. After hearing, I am deemed it proper to take cognizance and examine the complainant under section 223 BNSS. Order dated 11/3/2025. The cognizance was taken prior to 23/5/2025.
Yes.
Wherein the counsel of the petitioners also appeared before the trial court, and a hearing was done. After that, on 11/3/2025, the cognizance was taken by the learned trial court. And in the instant petition, the impugn order is reflected as 23/5/2025.
Yes, what is your difficulty in this page 70? Page 70 is what you are challenging.
No, my lord, 23/5/2025, that is a subsequent order, because after we submitted our objection, there was a hearing, my lord, and thereafter the summon was issued to the petitioners, my lord, by order dated 23/5/2025.
No, Your Honor, the summon was
Where is that order?
23/5/2025 was an
Page 58, my lord. Annexure 8, my lord.
prior to this cognizance was taken, my lord. On
Your entire, then I allow his case. Then I allow his case.
But
What does the order that you have given, that you have annexed at page 70, what does it say?
yeah, the second.
I have heard the learned counsel for so and so.
Yeah.
After hearing, I deem it proper to
Take cognizance
and
examine the complainant.
okay. What does 223 of the BNSS say? Kindly take it up.
223 of the.
While taking cognizance, he shall examine upon oath the complainant and the witnesses present. So first he has taken the cognizance. Now he says, I propose to examine. Can he do that? The cognizance has to be taken after the witnesses and the complainant have been examined on oath.
That is a
Thereafter, cognizance has to be taken.
yes, that is
So 11/3/25 goes. If it goes, then he has to start from zero again. So
That is
don't,
part of the.
so find out, read, we are reading it now. You are preparing it.
My contention is that, my lord, I may be given a fair chance whether this is a matter of civil dispute or criminal. So I may be given a fair chance to adduce my evidences in the trial court when the stages come, so that I can produce whatever documentation or other relevant
under
things are
stay?
there.
Is there a stay operating?
Yes, my lord.
Huh?
Yes, my lord.
This is a very premature stage, my lord. I may be given a fair chance.
Can we see the their petition, my lord, at page 35? What is the allegation against the petitioners, my lord? Page 35 and excerpt 6, my lord.
Hmm?
The very basis of the petition, my lord, what they have alleged against the petitioners, my lord. Because whatever she has complained, my lord, that is regarding the money and land, my lord. Money and land, and she is saying that I have sold the land to her and she has been evicted. She, not she, my lord, her mother. Mother knowingly, fully well that this is a government land. Because if it would have been Miyadi Patta land, there would have been a sale deed, my lord. Proper sale deed by obtaining sale permission and other things. And that would have been registered, my lord. It was mere a Kacha deed, my lord.
What if,
So she
if the
knowingly, my lord, she purchased it, the mother of the petitioner, my lord.
what if the
And,
petitioners were
from the that deed also it is apparent. She has accepted only the possessory right, my lord. So now she cannot claim other things, my lord.
He has hit the hardest. Now let us hear her also. She is making us. Yes.
My lord, what if he is already aware that there might be some eviction that is going around?
We'll allow the interim to continue for the time being. Get some more preparation. Otherwise, this is not a case where a criminal proceeding prima facie. At the consent of the parties, list this matter again on when do you want it? When do you want it?
First week of April.
Huh?
First week of April.
Have it on the 6th?
6th.
6th of April. Interim order passed earlier continues.
Can it be on the 8th, my lord? 8th of April, my lord.
8th of April.
19.
Obliged, my lord.
I'm sorry, my lord, item number 16, my lord. Certain facts from the miscommunication, my lord. In the joint affidavit, we have filed the quashing of our complaint case, my lord. So paragraph 9 and 10 in joint affidavit, it is must be reflected in the order, my lord. It is not recorded.
এইটো আপুনি লৈছিলে নেকি ফুলটো তাতে লিখি থৈ দিয়ক to reflect
Take the question.
para
Well, the quashing of a complaint, instant criminal revision petition filed challenging the criminal case, my lord. Quashing of this, my lord. So until and unless quashing, my lord, there's this petition, my lord. The trial court will.
you should have waited for the order. We have quashed the proceedings in the trial court and we have closed the criminal revision petition.
My lord, in criminal revision paragraph 9 and 10, my lord, joint affidavit, my lord, both the sides has for quashing. I'm sorry, my lord, my learned friend has said that this is not. I'm very sorry.
Nowadays it is available on the video.
Yes, my lord.
Listen to it, what is he said,
Yes,
what has the court said.
Obliged, my lord.
In case of doubt,
Yes, my lord.
refer 1. Otherwise, if it is not there, we'll add it up. Yes, sir.
This revision petition has been filed for quashing of the FIR
Hmm.
registered against disproportionate asset.
Okay.
Your lordship will find the,
মই তো কোন বহাব পাৰি নেকি গৰম উঠছে
will take some time. Yeah, only thing is that, my lord, if your lordship look as page 28, the FIR.
28.
8.
Huh.
And the next page, my lord. '29, your lordship will find the second paragraph. The report of analysis of assets and liabilities submitted by the MPanel CA in respect of
Where, page 29.
page 29. Further the movable.
Further, the movable record by the,
Acquired by the suspect officers so and so were rechecked and re-verified apart from his submitted statement of assets and liabilities. The assets and liabilities of the suspect officers were analyzed by an MPanel chartered accountant of this director. The report of analysis of assets and liability submitted by the MPanel CA, this will be necessary. Madam, your lordship has called for the case diary. Your lordship will kindly inquire whether this report is there in the note. Because this is ultimately the crux of the issue. We don't know how this report has been prepared. We have they have asked us to submit the assets and liabilities. We have submitted in the prescribed CBI format and all, and it is within the permissible limit. So your lordship will kindly inquire from my learned friend whether this report is available in the case diary or not.
no, this is a criminal petition.
Yes.
Are we supposed to look into the evidence part of it?
No, the report has your lordship has to look at it because in case of disproportionate asset, your lordship can look at it. Judgments of the Supreme Court, I'll come to it, but this report is the crux of the issues. So your lordship will kindly direct them to bring the report because there are cases of the. I can give the list of cases where the Supreme Court has quashed the FIR looking into this percentage, but that your lordship will definitely direct them.
Huh? Heard Mr. B.D. Kumar, heard Mr. B.D. Kumar, senior counsel, assisted by appearing for the petitioner, the learned APP shall produce the the learned APP shall have instructions on the report of analysis of assets and liabilities submitted by the MPanel CA in respect of the suspect officer, which has led to the initiation of the criminal proceedings against the petitioner. Mr. Kaur has submitted, and Mr. Kaur and his senior advocate has submitted that it will be a vital document for this court to form an opinion as to whether the criminal proceedings initiated against the petitioner would require an interference at this stage or not. List again on
lordship 12.3.
12.3. Have your instructions on that report?
We are deeply obliged.
21.
Yes.
The quashing petition filed by them, my lord. Quashing of a DV proceeding, my lord. Domestic violence.
Your lordship, in this matter, lordship, assisting counsel is that out of station. Matter may list after 2 weeks, lordship.
Sorry?
Assisting counsel, your lordship. This out of the station, your lordship. TS Odori.
There is a stay order in respect of the other respondents, madam.
Yes, lordship.
They have procured a stay order for the other respondents, madam.
All the respondents?
No, not for one.
Only.
Not for one.
Not for one.
Not for one.
And I have a small prayer, my lord.
So he was telling us.
Yes, actually, my lord, my assisting counsel, he is out of station. And he engaged me, my lord, he is out of station, but in next week, any date, my lord. Because there is already against the husband, my lord, proceeding is going on. So for his other member, they are living separately, there is already stay order is there. So my, if your lordship, my lord, dispose of the matter, whole matter, some other date, my lord.
At the request of the counsel for the parties, list this matter again on? List this matter again on 17th?
No problem. 17th March, no problem.
My lord.
17 March?
No problem.
Deeply.
Interim order pass earlier shall come.
The interim protection granted earlier shall continue.
Deeply open.
23.
Yes, sir.
Also conducting counsel, Mr. Airway is not feeling well.
Huh?
Airway is not feeling well, so he left.
My lord, we have not received the main copy of the petition. There is a delay contribution that was come down, but we have not received the main copy of the petition. Sir, a copy.
The learned counsel for the petitioner undertakes to serve a copy of the criminal revision petition upon the learned counsel appearing for the respondent.
Two.
Number 2. Full stop. List again on 18th of March.
May I please your lordships? This case, my lord, 528 petition, my lord. For quashing the my lord, impugn charge sheet and the my lord proceeding, my lord. As a matter, my lord, 279, my lord, and 304A, my lord. An accidental death of the husband of the respondent number 2, my lord. Then, my lord, immediately after the my lord registering the case, my lord, matter was at that moment, my lord, at that time, in the year of 2022, my lord, matter was settled, my lord. But as the affair has been lost, and accordingly that affair has been registered, my lord, and subsequently, my lord, charge sheet has been submitted. But in the meantime, both the parties have approached before the my lord police station, my lord, before the officer in charge, Moran police station. The petitioner from my lord Borpeta and my lord the respondent side from Dibrugarh Moran, my lord. That moment, my lord, as the my lord case has been registered, police has submitted my lord charge sheet. And even thereafter, my lord, they are my lord approaching some negotiation is going on, my lord, and ultimately, my lord, matter has been amicably settled, my lord.
Yes.
In the
Settle.
No objection, no objection, Lordship.
Huh?
No objection, Lordship.
No.
No objection, Lordship.
they have already filed.
No instruction. What? No
Objection, Lordship, objection.
They have already filed, my lord. I have received the copy, my lord. Already filed affidavit, my lord. They have filed affidavit, my lord. And in this regard, my lord.
Heard Mr. So-and-so learned counsel appearing for the
My lord.
petitioner. Also heard
My lord.
Respondent number 2, M. Rahman.
M. Rahman appearing for the respondent number 2. You are there on Wakalatnama?
Yes, I have filed already.
Do you have the Wakalatnama on record?
Yes, Lordship.
Huh?
Yes, Lordship.
It has been submitted in tandem before this court that the parties have mutually agreed that the husband of the respondent number 2 had been fatally injured in a road traffic accident and no culpability of rashness or negligence is being attributed by the respondent number 2 on the petitioner. Full stop. In such circumstances, this court is of the opinion that the conviction of the petitioner in case the proceedings in Moran in PRC case number 1031 of 2022 under section 279/304A of the IPC pending before the learned Chief Judicial Magistrate Dibrugarh is very rare, and since the parties have decided to since the wife of the deceased has filed an affidavit to the effect that she has compromised the matter with the petitioner. Stop. No purpose in law would be served if the said proceedings, namely number PRC case number so-and-so, is allowed to continue. Full stop. In such view of the matter, at the consent of the party of the alleged accused and also of the wife of the deceased person who had expired in a road traffic accident, this court pauses the proceedings under so-and-so Full stop. The criminal petition is accordingly disposed of.
Much obliged, obliged.
For hearing, item 47.
Wait, Your Lordship.
Yes, madam.
Lordship, this revision petition is directed against an order dated 21/5/55 passed by the Principal Judge Family Court, whereby the petitioner has been directed to pay a monthly maintenance allowance of rupees 4,000 to the respondent number 2, who is alleging to be my wife, Lordship.
Who is alleging?
Yes, Lordship.
How?
I dispute, Lordship, because I deny that any kind of marriage was solemnized between me and the respondent number 2. Because, Lordship, the respondent number 2, she happens to be my maternal aunt. She happens to be my mother's sister, Lordship. So how can a marriage be solemnized?
Even if it is solemnized, it will come within the prohibited
Lordship.
But there are two
null and void marriage.
technical issues there, madam.
Ah,
First issue is that, madam, probably this will go before the division bench, madam. Because it arises out of a final order passed by the family court. So there are two notifications, madam, I have got.
Lordship, for nullity of marriage, I have already filed a petition before the learned trial court, Lordship. That's pending in Borpeta, Lordship.
so you admit a marriage,
Lordship,
you are now trying to get it nullified.
they forcibly took my signatures on some papers, Lordship. And later on, I came to know that those were used for solemnization of the marriage, falsely forging my signatures, Lordships.
This order is passed by whom?
Family
This-
court, madam. Principal Judge Family Court.
Lordships.
Nowadays, madam, all these such matters are going before the division bench, madam.
When there is a family court, it goes before the division
Yes,
bench.
this is the family court.
Where there is a designated division, family court, it
Ah.
comes before this.
This
is a
passed
family
by
court.
Principal Judge Family Court, Borpeta.
Yes, madam. Matrimonial appeal arising from the order and judgment of the district court other than the family court.
Revision is permissible, Lordship.
No, revision is permissible because of the exception carved out under section 19 of the Family Courts Act. But this revision will go before the division bench. That's the only issue here.
What do we say? Caught on the wrong foot or caught on the unprepared foot? Huh?
Lordship, at this point, actually, I was not prepared. So, can not just grant me one time, Lordship?
We are not required to dismiss it because it is listed before the long bench. We cannot dismiss it.
And second issue is also there. Came straight away from orders to hearing, not on admission. So records were also not called for.
Lordship,
Probably,
it's been listed for admission. That
probably,
is true, Lordship.
probably records will also be required.
Why? Are you the wife for notice the only issue?
Evidences will be required.
Are you the wife for notice the only issue?
Yes, evidence will be required, madam, probably.
Produce certified copies. Huh?
I don't know. Maybe.
Are you sure these are the latest
Yes.
notifications?
Lordship can verify, but to my knowledge, madam, this is.
We'll send it to the
Confirm, Lordship.
registry.
Registry, madam.
Now the council appearing for the respondents. The sole respondent has submitted that this matter is required to be matter is required to be listed before a particular bench, namely the division bench 1, since it is a matter arising out of an order passed by the learned
Principal
family
Judge
court,
Family Court.
principal judge,
Family Court.
family court Borpeta, for family court full stop. Registry to verify and list accordingly.
Records on it and records been on that. Records also.
Her parents-in-law is, what she says is her sister.
Maternal uncle.
No, PW1's parent-in-law will be the sister.
Lordship. How can that be? Under prohibited degrees, Lordship. How can a marriage be even solemnized? When it is already bad.
Hmm?
When it is already bad.
We are at an advanced age.
Cheers.
Let us not question relationships anymore. Thank you.
Lordship, item number 11, sorry, Lordship.
No, huh?
11, Lordship.
Ah,
Recent time, Lordship has reserved this particular.
you will
Yes.
record your presence at best.
No, Lordship, the instruction I'm having, I'll place this instruction, Lordship.
Just tell us. Item number 11, huh? Mr. Das, you have to help us. Mr. NC Das has appeared in the item 11.
11.
Item 11, we had recorded his absence. No, we had recorded his absence. But now since he has put in an appearance, we'll.
With the instruction I have received.
To
Application,
what,
Lordship,
to what? This office memorandum says that he's entitled to
Yes.
something.
Entitled with regard to this, it has been mentioned that he is entitled only when certain conditions are fulfilled.
Which condition?
This is 5 lakhs, if your Lordship kindly see in the second.
That
page.
occurring due to accidents during the course of performance.
Exactly.
Performance due attributable to acts.
So it has been specified here like that. Okay, good, please.
Then you have paid that other fellow. How? He was involved in an accident.
Exactly.
You paid him,
Yes.
not under the office memorandum.
But in the affidavit, to some extent, we have clarified that aspect of the matter. Then also.
Saying what?
In the affidavit, this, in paragraph, if your Lordship, paragraph, the record is not there. In paragraph number 11, it has been mentioned, Lordship. This is that with regard to the statements made in paragraph 10 of the writ petition, the answering respondent beg to state that as per GOI, MHA, OM rated such and such personnel who were disabled in the performance of their bona fide official duties under various circumstances and boarded out on account of disability attributable to or aggravated in service shall be paid ex gratia compensation. However, in this case, as per the GOI proceeding, the individual suffers stroke hematoma during the late night hours on 23/8/2015.
No, the other fellow had suffered it when he was going on a scooter at his home on leave.
But it has been clarified like that, Lordship.
Then the clarification doesn't work. We'll take care of the no clarification. But otherwise, since it has been given to someone else and this has been this disease,
Yes.
your office memorandum cannot override what is given in the this thing, extraordinary pension rules. So once it is attributable to service, he'll be entitled to ex gratia. Is what is our tentative view.
Yep.
In case we have any different line of thought coming up, we'll have it either
Exactly.
spoken to or for a re-hearing.
Yes, Lordship.
If there is some clarification required, kindly inform that we'll record his name and that he has given us a office memorandum. That order in item 11, it will read as heard Mr. NC Das, learned senior advocate, assisted by so-and-so. Also heard Mr. SP Chaudhary, learned CGC, who has produced the office memorandum. Arguments concluded, judgment reserved.
It may be kept on record, Lordship.
You have produced it.
Yes.
I've seen. Thank you.